hearings first, so go ahead and start the YouTube.
We're almost there. We're live.
Morning, everyone. I'm Jim Dill. I'm the Senate Chair of IFW Committee, and I want to welcome everyone to our committee hearing today. We got a very ambitious day. We have 2 public hearings followed by 9 work sessions. So we will get right to it, and I will start with introductions. And first is Representative Alley.
Thank you, Senator. I'm Robert Alley from down in the Yorkville Beals area, District 138. We have 12 communities that I take care of, so thank you.
Thank you. Representative Terrio.
Thank you. Good morning, Senator. My name is Tim Terrio. I represent District 79, which is Albion, most of Benton, China, and Unity Plantation.
Representative Hepler.
Good morning, Senator Dill. I'm Allison Hepler. I represent House District 53, which includes the towns of Aroustic, Georgetown, Phippsburg, Woolwich, where I live, Dresden, and a small part of Richmond.
House Chair Landry.
Good morning, Senator Dill. I'm Representative Scott Landry, live in Farmington, and represent District 113, which includes the communities of Farmington and New Sharon.
Representative Neto.
Good morning, Senator Dill. Kathy Neto, representing District 78, which is Winslow and a small portion of Benton.
Senator Black.
Thank you, Mr. Chair. Good morning, everyone. I am Russell Black, Senator Russell Black from District 17, which is all of Franklin County and 4 towns in Kennebec County.
Representative Martin.
Thank you, Mr. Chair. Good morning, folks. Danny Martin, House 150, located in northern Worcester County.
Representative Ordway.
Yes, good morning, everyone. I'm Lester Ordway. I represent District 23, which is most of the town of Standish.
And we have Linda LaCroix, our clerk. And Linda, could you make both Scott and I co-hosts when you get a chance?
Have done already.
Okay. And let's see, who else do we have? John, up in my right-hand corner. John Clark is our analyst for today. He'll be taking notes, and then we'll get to the work session. He'll be summarizing all of our bills there. And as I mentioned, I'm Jim Dill. I represent Senate District number 5, Northern Penobscot County. And as I say, we're starting out with 2 public hearings. So I would ask everyone to keep yourselves muted, please, until you need to ask a question. Be respectful at all times. And what we'll be doing is we'll be going through for our testimony. We'll start out with the bill sponsor, or the legislators, the department, and then folks that want to testify, and we will go in the order of in favor, against, and then finally neither for nor against. And there will be a timer of 3 minutes, at which time I'm not trying to be rude, but I will let you know that your 3 minutes are up, and I'll ask you to summarize in a sentence or 2. So with that, if there are no questions, or if my co-chair doesn't have anything he wants to add, we will go ahead and get started. And the first thing we have is we'll start with LD 770, an act to apply the civil trespass law to hunting dogs. Representative Terrio.
Thank you, Senator. Good morning, Senator Dill. Representative Landry and esteemed members of my committee. My name is Tim Terrio, and I'm here to represent, I represent China, Albion, and Benton, and Unity Plantation, and I'm here to present LD 770, an act to apply civil trespass hunting codes to hunting dogs. But I also would like everybody to know that I am introducing an amendment to the bill. The amended version is what we are going to talk about, because we had a stakeholders group put together, and the it was a very good group of people that got together talking about this, and they had several meetings, and the hunting dog people actually came up with this language. So I am very supportive of what they've come up with. It's nothing I came up with, but that's what we're going to be discussing. I'll have John share it on the screen when we get ready to start talking about it. I'm here to present an amended bill for the department. This bill covers the gray areas of some hunting regulations. The objective is to make these definitions more clear and subsequently improve compliance. The overreaching reason is for the amended bill is to improve relations between landowners, hunters, and their hunting dogs. And I'll be happy to answer any questions.
Are there questions for Representative Terrio?
I don't know if John wants to share that amendment on the screen, or is it all right? Just everybody should have gotten that
Yeah,
amendment.
if John can share that with us, Representative, that way we all can see it together, I think, and you can walk us through it.
Right.
All right, can you see the amendment there?
Yes.
Yeah. Can you make it a little bigger, John?
Sure.
Awesome. There you go.
Good.
So this is the language that they came up with, that they came from Minnesota. It's been on the books for 25 years and has worked very well. And they said that it covers a lot of the problems. I mean, is it perfect? Probably not, but it's certainly a tool in the toolbox for the wardens to use to take care of the bad actors that we have, that we've been unable. Apparently, there's some people that have had problems for 25 years with this, and there's been no resolution. So this is a step in the right direction. So hopefully everybody realizes that. And we need to make sure that our landowners are protected. So this is the tool that's going to make that happen.
Will I stop sharing now?
Well, I say,
Before you do, I do have a question. So Tim,
yeah,
I see it's kind of, excuse me, Representative Terrio. I see it's listed out there. So bird hunting and rabbit hunting dogs are not covered under this. It's just more, right?
that's correct. Yeah, right. It was coyote, bear, fox, bobcat, and raccoon. Those are, because what the hounders were worried about is if they kept it to coyote or bear or whatever, they could say, well, we're out hunting fox, or we were out hunting bobcat, you know, another predator type animal. So they said, well, if we cover all of them, and these are, like I say, these are their ideas. So I was very pleased that they came up with this, you know, to cover the bases, to make sure. Because if you're doing nothing wrong, if some landowner comes up to you and says, please don't hunt on my land, 99 people out of 100 are going to say, yeah, no problem. And it's for the people that are getting in the landowners' faces and being very rude and saying, it's not against the law and I'll be back tomorrow. And those are the guys that are, you know, they know who they are, and they know what we're going to do. So if you're not doing anything wrong, this doesn't affect you at all.
Okay. Are there any other questions for Tim? Representative Terrio, I mean, sorry. Representative Hepler.
Thank you, Mr. Chair. Thanks, Representative Terrio. I had a question that I think you said, and I may not have heard it. You mentioned a stakeholder group. Who was in that?
All right, there were the hounding people, all the people that hunt with hound dogs, Sam, Tom Dokes for the large landowners. There were two people that have had problems with this. They were part of it. They were two different ladies. One was a main guide. So, I mean, she's an actually active hunter. So, you know, there was a very wide range. The warden service was involved. Myself, Don Kleiner was involved. So the guides Service was represented. There was a very good wide variety of people, so it was well represented.
Thank you.
Yep.
Are
And
there
we-
other questions?
And we
Are
had
there other questions? Yep,
several meetings.
several meetings.
Yes.
Are there other questions? All right, seeing none. Thank you for presenting this morning.
Thank you.
Next, we'll have, let's see, is it going to be Colonel Scott or is it Deputy Commissioner Peabody?
If Colonel Scott's in the waiting room, we'll bring him in. If he's not there,
Okay, I'll go ahead and look. See if
Senator Dill?
Yeah.
I'm sure he is there, but a link was shared, so there are 5 of one person, and I don't know who is who. I've been trying to figure that out in communication with Crystal Terrio.
Sure, will the real Dan Scott please stand up? All right,
Okay,
So I see
maybe
a hand
that's it.
raised.
Yep, I see it. I'm bringing in that person. Hopefully it's Dan.
so before Colonel Scott, if the other Crystal Terrios could rename themselves.
I don't believe they can until they
can't?
actually come
Okay.
in.
They can't
So-
until they get let in, okay.
Unless
Anyway.
they find another link.
Okay, we'll figure it out.
Yep.
Okay. Colonel Crystal Terrio, Dan Scott. Crystal will be happy that she's got a promotion.
Maybe this will make my testimony more comprehensible today as well.
Good morning, Colonel.
Good morning, Senator Dill, Representative Landry, and members of the Inland Fisheries and Wildlife Committee. I'm Dan Scott, Colonel of the Maine Warden Service, speaking on behalf of the Department of Inland Fisheries and Wildlife, speaking in support of LD 770. This bill prohibits a person from engaging in an activity governed by the Inland Fisheries and Wildlife laws from allowing the person's hunting dog to enter or remain in any place in defiance of a lawful order not to enter or an order to vacate that was personally communicated to that person by the owner of the place or an otherwise authorized person. This is a landowner relations issue that wardens and landowner relations program staff have been dealing with for a number of years. It seems to generate a lot of concerns, and logically a landowner should be able to tell someone that they can't partake in a specific activity on their land. Currently, Warden Service has no way to adequately address these complaints. The department has been actively involved with a group of stakeholders representing both sides of this issue to better inform the committee during the debate and deliberation of this bill. Representative Terrios, the sponsor, has brought forth additional language which was most agreeable to the stakeholder group. The new language prevents a person's hunting dog from being released onto the land which is posted in accordance with criminal trespass laws, as well as property upon which a law enforcement officer has, within the previous 365 days, provided written communication to a hunter that their dog is prohibited on the property. We believe the new language represents a sufficient compromise amongst individuals on both sides of this issue and provides the Warden Service with the necessary tools to address complaints as they arise. As Representative Terrio had said, we had sufficient, fairly comprehensive representation in the stakeholder group from both the landowner relations side, as well as the hunting side, as well as the Sportsmen's Alliance of Maine, and through a couple different meetings, as well as some sidebar discussions. The Hounds folks brought this language forward, and we do feel that it represents some good middle ground and gives my staff the opportunity to have some tools to deal with these issues as they come up. And I'll be glad to answer any questions at this time or during the work session. Thank you.
Are there any questions for Colonel Scott? All right, seeing none. Thank you for your testimony. Next is Claire Perry, and followed by Steve Wood.
Both on their way in.
All right, so next we have Claire Perry. If you could unmute yourself, please.
Yeah, hello, I'm Claire Perry. Honorable Senator Dill, Mr. Landry, and members of the committee. I was included on the stakeholders meeting, and I have to say the results of the meeting, of the first meeting, I felt included. I did feel included and I felt heard. The results of the second meeting were all about a bill change that was done behind closed doors. It was done, I believe, between David Trahan and the hound dog owners. That was what we were told, that we would be having no more meetings after the first meeting until David Trahan came up with a complete bill change that they felt was for the better. I wasn't included in any of those talks. I was not included. I think it's important for everybody to hear that. Our stakeholder meetings were put on hold for several weeks until Mr. Trahan could come up with the proposal that he and the hound dog owners liked. And that was what we were presented with a handful of days before the bill was to come up. And I think Tim's first bill, the real 770, was not perfect at all either, so quote unquote, when they're saying nothing is perfect. But it did give the landowners the ability to have the control of being able to get a viable arrest because the hound dogs would be entering our property. Not with this bill, we have to see them being turned loose on it. And really, you guys, how many of us are out there watching our property when these dogs are turned loose? The dogs can be turned loose a mile up the road, come onto our property, and this bill does, it will not afford us what we need in court. I had an attorney look at it. I was so concerned and I was told it was okay. I had an attorney tell me what's going to happen when this comes before a judge. A judge has only what's in front of him is the law written to convict on. There's no way a landowner is going to get relief from this. Maybe one if he catches somebody turning the dogs loose right on the property rather than being found there. And there's no time for others to testify on this. People that testified on 770, reading it as written originally, have written, but 770 isn't the 770 that those people felt they could support. I wrote to Tim and I wrote to Colonel Scott, and I told them in good faith I would have to trust that they were telling me this was a good bill and they could get to court and get convictions. But after speaking to that attorney, you know, I'm not at all convinced that that's going to happen. And I think I can't say that I support it, and I can't say that I was included in it because I was totally not. I was not included, not one time. So, and I don't think that's right. So I just thank you for your time. I don't have anything more to say, but I can answer questions.
Okay, thank you. Are there any questions? All right, seeing none. Again, thank you for your testimony this morning. Next is Steve Wood.
Good morning, Senator Dill, Representative Landry, members of the IFW committee. My name is Steve Wood. I'm a registered Maine guide, lodge owner, and I support this bill because there is a lot of problems out there and it's time that it needs to be fixed. The only thing I see about this bill this amendment is there's nothing that stops the problem of hound guys running off someone's bear bait site. Right now, they can't release a hound within 100 yards of a bait site, but most bait sites are more than 100 yards from the road. And as my previous hound guy that I hired to run hounds for me state, you know, I'm not breaking the law. I can release my dogs right here in this road. They can run down the trail to my bait site, and they're not breaking the law because my bait site's 150 yards off the road. So there's more language needs to be added to this bill, in my opinion. So that's all I have. I can answer any questions.
Are there any questions for Steve? Seeing none, thank you for your testimony. Linda, that's all I have on my list. Tim, Representative Terrio.
Yes, I would like to ask Colonel Scott if he could clarify what Claire Perry was saying, because I believe what she's saying is covered in the bill, and she just, for whatever reason, doesn't want to believe it. I believe we addressed it, but I'd like to hear clarification from Colonel Scott, please.
Sure, all set, Senator
Yep.
Dill?
Yes.
Yeah. So yeah, I do believe that there were some, like as I put in my testimony, some sidebar discussions just so we could kind of find some middle ground. This is a fairly divisive issue. There were discussions between the Hounds Group and the Sportsmen's Alliance of Maine and the department to try to find some language that we could then present to the entire group, which we did. I do think that Representative Terrio's amendment, if Ms. Perry looks at paragraph 2B. So this is even ever so slightly different than what the stakeholder group looked at last week. So I don't know where she would have been able to show the amendment to her attorney, but 2B I think addresses her concern. It speaks to so that the hunting dog enters onto the property of another. So we clarified at our last stakeholders meeting that on already posted, currently posted property, the statute speaks to that a person may not release a hunting dog onto that property. More or less, you know, there's a sign out ahead, you release the dog knowing it's going to go on to the property. Under Ms. Perry's situation where somebody has been previously notified within the last 365 days, a hunter has been notified to not have dogs on that property, and the dogs have been found on that property in the past, the hunter cannot release the dog so that it ends up on that property. In many, many situations, due to the escape routes of wildlife, if you start in a particular area, the bears, the coyotes, et cetera, what have you, tend to run in the same direction. And that's why we tend to see multiple complaints from the same landowner around these situations. The amendment that was brought forward addressed that in in paragraph B, and I think that Ms. Perry follows up with that. She'll find that answered some of her concerns. We specifically talked about that in our last stakeholder meeting. Thank you.
Senator David Trahan says he's trying to get in and can't get in, so.
Okay, I'll have, could you let in David Trahan, please, Linda? I do have a question for Colonel Scott. So, Colonel, if I'm out bear hunting and I release my dogs and they're chasing a bear and this bear just books it a mile through the woods and ends up on somebody's property that's posted, and they're out there after the bear and I'm the landowner and I call the warden service and they come out, they find out who those dogs belong to. And if I understand this, there would probably be given a written warning to those dog owners at that time. And then if in the next year that happens again by that same dog owner, then they would be liable to be fined. Is that the way I'm reading this?
Yes, sir.
Okay, thank you.
That's that's paragraph A as you described it. In paragraph B, if same situation, if it ends up on a property that's not posted, so the dogs are found to be on somebody's property, they catch them there, they do not want them there, they contact law enforcement. We provide the hunter with written notification that they're not wanted on the property. If the dogs return within 365 days, that would be a violation.
Okay. So I'm just making sure that what Ms. Perry was saying, that, you know, it is covered here, that, you know, I'm not actually going up to somebody's property because I've seen a bear and or whatever and release my dogs onto their property. That if the dog, by following the prey, ends up on someone else's property, they could be in violation.
Yeah, with the notice.
Yeah.
If somebody has posted property and I stand 100 yards from it and point my dog in the nose in the direction of the property and send them over there, they can be immediately in violation at that point if they release it directly onto posted property.
Right. But if they stumble onto posted property eventually, then it goes back to the other process. So,
Yes, sir.
yep. Thank you. Are there other questions for Colonel Scott while we still have him there? All right. Seeing none. David Trahan, would you like to testify?
Yes, Senator Dill, Representative Landry, members of the committee. Thank you for the opportunity to testify on this bill. A previous speaker was exactly right. We were involved in the amendment that was created, and we take great pride in that. We would like to thank the members of the hounding community who stepped up in good faith and tried to work to address this problem, taking into consideration and respecting the rights of landowners. I do want to speak to the process. It was obviously a controversial bill, and yes, the previous speaker, when we had our first meeting, it was obvious that without some middle ground, we were not going to come to a good conclusion on this bill. We all started from very polarized positions, but because of the good faith efforts of the people involved in the stakeholders group, it was obvious that there was a problem that needed to be resolved, and we wanted to be part of that resolution. And it was why I asked the committee to allow us an opportunity to work with the hounding community, the people who are most affected by this law. If you remember the beginning of this legislation where it started, it involved anyone that had dogs that were hunting in the outdoors. It included rabbit hunters, grouse hunters, duck hunters, anyone could possibly be affected by this bill. But you all heard why this bill was brought. It was because specifically coyote hounding and some incidents related to bears. Our role in this was to try to narrow this to address the problem. And there are really no problems with grouse hunters using dogs, rabbit hunters using dogs. On occasion, maybe once in a while, but do we need a law to address it? And the answer for us was no. So that was why we worked to craft a bill to strategically and responsibly address the problem. There was no hiding behind closed doors. It was a good faith effort by us and the hounding community to address this problem. And I wanted an opportunity to say that. We are very proud of the product that we helped produce. We did have a stakeholders meeting to review it. And other than one person criticizing it, I think we came up with a good product. Lastly, I want to make a point that I made to that previous speaker. I think her greatest concerns were she did not want hounds to ever end up on her property. In order to do that, you would have to regionally ban hounding in that part of the state. And I pointed that out to the previous speaker. Those landowners that are next to her property have a right to defend their livestock, their pets, and their property. And if they want to manage coyotes, then they should have this tool available to them. So in a sense, regionally banning hounding is negatively impacting landowners that feel differently than the previous speaker. For that reason, we hope that the committee will accept this amendment as written. Any significant changes to make it broader or more like the original bill, I wanted you to know we would strongly oppose. So with that, thank you for the opportunity to speak.
Thank you. Are there any questions for Mr. Trahan? Seeing none. Thank you. And with that, I think that concludes the people that we have listed to testify. Is that correct, Linda? Yep. Okay. If there are no other questions, then I will close the hearing.
Senator?
Yes.
I'm terribly sorry I couldn't unmute fast enough. I just received an email from Tom Doak, who also wishes to testify on this bill.
All right. I thought originally he was going to, but all right. Would you let him in if he's in the waiting room, please?
Yes, I will. On his way.
All right. Good morning, Tom.
Good morning. Thank you, Senator. I've been trying to get in, so I'm sorry for the delay. Senator Dill, Representative Landry, members of the committee, my name is Tom Doak. I'm the Executive Director of the Maine Woodland Owners. I did serve on the task force, the stakeholder group, and I'm testifying in favor of the amendment. It isn't a perfect amendment. This is a difficult issue. I do appreciate all the discussion that went on. I mean, it is still a person that doesn't want dogs on their land. Still, the burden is still on the landowner to either post it or find them and report them. But it is moving forward, and I think it does give the tool to the warden service and others to deal with the issue of the people that are really causing the problems. And one of the things that impressed me in the discussions, where I think we all recognize this isn't perfect, but also the commitment from the department to say, okay, if we move forward with this gives us the tool. And if this tool doesn't work, you know, if we find out it doesn't work the way we think it will, we will make adjustments because they're taking this issue very seriously. So I'm happy to be supportive of this amendment, and I appreciate all the work that went into it.
Are there any questions for Mr. Doak? Seeing none, thank you. Anyone else, Linda?
Not that I have on my list.
Okay, so remember, folks, if you want to try to get on to testify, there is a portal to go through to get to the clerk, and we prefer to be sure that you are signed up 30 minutes in advance so that we can be able to get you into the system. So with that, I will close the hearing on LD 770. And we'll move on to LD 1474, an act to promote outdoor recreation opportunities for Maine students. Representative Dunphy.
Senator, I do not see Representative Dunphy in the waiting room. I have been watching for her, and she has not shown up as of yet.
Okay. Let's see. All right, so I'll open the hearing on LD as they did 1474. We worked this bill pretty hard last year, and I think it got caught up with when we left because of COVID. You all should have a copy of the bill, and I'll quickly read what it says here. The bill creates a pathway for public and private elementary and secondary schools and post-secondary education institutions to safely conduct overnight camping trips to primitive camping areas in the state for students and adults associated with those institutions by establishing an educational trip leader permit and the laws governing guides and youth camp trip leaders. Using the youth camp trip leader permit as a model. Schools currently conducting these trips as part of their programming have until October 1st, 2022 to comply with the new permit process. It requires camping trips to be led by persons who have obtained an educational trip leader permit. It also establishes the advisory committee for educational trip leader permits to provide advice to the Commissioner of Inland Fisheries and Wildlife regarding the permit and to regulate the educational trip leader instructors. So I will first turn to Representative Dunphy's not here, so I'll go right on to Dan Scott, if you can he's still there, right in the middle. And I hope so that I see Linda's got her hand up. Do we have Representative Dunphy?
She is on her way. She said that she's in the waiting room, but I can't find her, so I just sent her another link.
All right.
to get in. I've been through it all. I've tried searching for her, and I don't know why she's not showing up. It's one of those mornings, I guess. But she is on her way.
All right. We'll wait a second then. We'll put Colonel Scott on hold. I still am not seeing her though.
It might take a few minutes for her to get the link and register.
Okay. Well, why don't we go on to Colonel Scott anyway? I believe he's going to be testifying in favor, so we'll do that, and then we'll come back to Representative Dumpy.
Yes, sir. Good morning, Senator Dill, Representative Landry, and members of the Inland Fisheries and Wildlife Committee. I'm Dan Scott, Colonel of the Maine Warden Service, speaking on behalf of the department in support of LD 1474. This bill creates an educational trip leader permit program within IFW, which allows private elementary and secondary schools and public and private post-secondary educational institutions to, without a guide's license, conduct paddling and primitive camping trips for students and adults associated with those institutions. For many years, educational institutions have been conducting trips into the Maine outdoors, providing students a variety of outdoor education and peer leadership experiences. In many situations, the trips include paddling opportunities and camping at primitive camping sites, which, if conducted in conjunction with remuneration, require a Maine Guides license. While these trips are sometimes led by registered Maine Guides who are either regular employees of these institutions or hired specifically for the excursion, especially at Maine's colleges and universities, they're often led by fellow students who have undergone extensive training, including wilderness safety. The long-held assumption of most institutions was that because the students participants were typically not being paid directly for the excursions, nor was their trip leader being directly compensated, they were not required by state law to hire a registered Maine Guide for any paddling or overnight primitive camping. Last year, representatives from the University of Maine System and the Maine Independent Colleges Association approached the department's Guide Advisory Board, raising concerns and questions, attempting to clarify on whether they were violating guide licensing laws and taking students on a variety of outdoor trips. The department agrees that a resolution was long overdue, and by clarifying what is and is not legal in either law or rule, or both, makes sense. As a result, last session's LD 1932 was proposed. 1932 required IFW to establish a task force of stakeholders to convene and report back with a recommendation to resolve the question. LD 1932 passed unanimously out of this committee, but unfortunately died when the legislature adjourned due to the pandemic. However, agreeing a remedy to the educational trip leader question was necessary. We convened a task force of stakeholders which developed a program permitting educational institutions to have certified educational trip leaders to lead their valuable peer leadership outdoor experiences. The task force included 15 members representing public and private post-secondary education, public and private K through 12 education, nonprofit organizations which coordinate outdoor education for K through 12 schools, a member of the Camp Trip Leader Committee, a representative from the Guide Advisory Board, a representative from the Maine Professional Guides Association, and representatives from IFW. Among the 15 various task force representatives, 12 are currently registered Maine Guides. The task force held a number of meetings throughout the fall to develop a program outline and path moving forward. The final report of the task force and their proposal is complete and has been presented to the committee. Included below are some of the task force recommendations. One is to have the IFW commissioner promulgate a series of rules which provide for the desired program, including establishment of an educational trip leader advisory committee. The committee would be made up of similar representation as the task force, including representatives from public and private educational institutions. The advisory committee will develop and adopt a curriculum for the training, testing, and certification of educational trip leaders, including a minimum standard curriculum of wilderness first aid training or higher, training or current certification in CPR, group management and facilitation, risk management, wilderness tripping skills, campcraft skills, and Maine outdoor industry and further experiences. Each educational institution wishing to participate in the Educational Trip Leader program will identify a program administrator who is approved by the Advisory Council and is also a registered Maine guide. If no person affiliated with the institution meets the registered Maine guide standard, the advisory committee can approve one from outside the educational institution who meets the qualifications of the administrator. The administrator oversees the institution's program, trip leader certification, and suite of trips. The bill before you, LD 1474, is a critical step in the process I just described. It sets the groundwork for the Educational Trip Leader program based upon the recommendations of the task force. It contains a provision for institutions currently conducting these trips as part of their programming to continue to do so until October 1st, 2022, when they will need to be compliant with the new permitting process. The same deadline also provides the department the needed time to complete the rulemaking process. It requires trips to be led by persons who have obtained educational trip leader permits. It also establishes the Educational Trip Leader Advisory Committee to provide advice to the Commissioner of Inland Fisheries and Wildlife regarding the permit and to regulate educational trip leader instructors. The only recommendation from IFW, of which we have already consulted with the bill sponsor, Representative Dunphy, is between now and work session to allow us and several representatives from the task force to streamline the bill by removing language from the bill which we feel would be better promulgated in our rules. I'll be happy to answer any questions at this time or during the work session. Thank you.
Are there any questions for Colonel Scott? Seeing none, thank you for your testimony. And I will go back to Representative Dunphy. Welcome.
Thank you. Thank you. Thanks for your patience with me. And it's a pleasure to be here before this committee, which is always one of my favorites in the legislature. So Senator Dill, Representative Landry, and distinguished members of the Inland Fisheries and Wildlife Committee. My name is Michelle Dunphy. I represent House District 122, which is comprised of Old Town and the Indian Island voting district. And as you know, I am here to present to you LD 1474, an act to promote outdoor recreational opportunities for Maine students. And this bill has had a colorful history. I was the first approached to sponsor this legislation by our partners at the University of Maine in the 129th legislature. I was happy to do so to address the lack of clarity in the law regarding educational trips versus professionally guided recreational experiences. And at that time, there were concerns about the safety of people participating in school-sponsored outings if those excursions were led by unqualified trip leaders. While many schools and colleges assumed that sponsored trips were exempt from legal requirements to have professional guides as trip leaders, it became apparent that this was not the case. The adherence to the law was, as a result, pretty spotty, and some institutions who already had professional guides on staff had no issue complying with the letter of the law, but then those who did not risked liability. So the original bill simply exempted institutions from the requirement to retain the services of guides. The public hearing revealed a need for something else, and the subsequent work session discussion called for a process to qualify trip leaders in lieu of the guide requirement and limit that trip leader designation to educational institutions only to prevent abuse of the designation. But then, as we all know, the pandemic struck and any of our pending legislation died with the end of session. But happily, the department took the project on, hosted a working group that met several times over the course of the past year. And as a result, the legislation that addresses all of the original concerns and posts a series of structural steps that will allow this mechanism to be put in place as a resource to schools and a protection to students on these types of trips. And I'm really proud of the amazing work that's been done to get us to this point. And I'm very proud to be sponsoring this legislation. I'm thankful to all the stakeholders who participated in this process to develop such a thoughtful product. And I strongly feel that the proposed legislation protects students, the institutions of learning, and it protects the professional guides culture as well. Safe educational trips, as we all know, help cultivate a strong love of our outdoor and natural resource heritage, and this legislation advances this cause. And thank you for your attention this morning. Thank you for your patience with me as I was stuck in the virtual waiting room. I'm happy to answer any questions. I'd also like to extend a thank you to Colonel Scott for jumping right in there for me and giving his testimony. And as he stated as well, we do have an amendment coming for a work session. Thank you.
Great, thank you. Are there questions for Representative Dunphy? All right, seeing none, thank you for your testimony.
Thank you.
Okay, the next three I have on my list are Lauren Jacobs, Chris Bartram, and Christopher Haywood. So Lauren Jacobs, if you would unmute yourself.
Hello, everyone. Senator Dill, Representative Landry, and distinguished members of the Joint Standing Committee on Inland Fisheries and Wildlife. My name is Lauren Jacobs. I live in Old Town, and I'm a lecturer in outdoor leadership at the University of Maine, and I'm a registered Maine guide. I'm here to speak in strong support of LD 1474. It was my honor to be able to serve on the task force that worked on this throughout 2020-2021. My role on the task force was to represent our outdoor academic program at the university, but also to do my best to represent the needs of Maine's K-12 educators and students. I've been a physical education teacher in Maine, and in my current position at UMaine, I instruct our future physical education teachers and work closely with schools around the state on developing outdoor education programs. With competing priorities and limited resources, Maine educators and schools need support in getting their students outdoors and active, which is why it is so important that the department and the task force took on the challenge of working through this longstanding issue. To me, the most exciting thing about the proposed educational trip leader permit system is that it provides a clear pathway to supporting Maine students in getting safely outdoors by supporting their schools with a clear training and certification process that sets a high but achievable and appropriate bar while promoting safety above all else. It was very important to the task force that this process is opening a door to outdoor education and activities, in part by removing existing barriers that may have unintentionally limited outdoor leadership opportunities for students. Additionally, this proposed system provides a clear pathway to building our state's future outdoor leaders. It recognizes the value of having higher education students lead their peers and provides a framework that will ensure they can safely do so, while also helping educators in other settings develop key knowledge and skills, including about career opportunities in Maine's outdoors. The students of today, whether in K-12 or higher education, are tomorrow's future outdoor business owners, guides, teachers, nonprofit directors, and land protectors. Over the last year, the pandemic has shown all of us how important the outdoors is for our physical and mental well-being. As this committee knows, the outdoors is also a critical part of Maine's economy and way of life. This bill will support both the needs of Maine students and our overall outdoor industry through workforce development. Thank you for your time and consideration, and I would be happy to take any questions.
Are there any questions? Seeing none, thank you for your testimony this morning. Next is Chris Bartram.
Good morning.
Morning.
Senator Dill, Representative Landry, and distinguished members of the Joint Standing Committee on Inland Fisheries and Wildlife. My name is Chris Bartram. I'm the Assistant Director of the Maine Bound Adventure Center here at the University of Maine, which provides opportunities for students to safely recreate outdoors through student-led and other trips. I'm also a registered Maine guide, and I'm here to speak on behalf of the University of Maine and the University of Maine system to speak in strong support for expanding opportunities for Maine students to safely experience the outdoors, as proposed by LD 1474. Mainbound first started outdoor education programs in 1986. That was before I was born. In the years since, we've safely taken thousands of students into the woods and waters of Maine, fostering a lifelong passion for the great outdoors, a commitment to its stewardship, and in many cases, a pathway to the outdoors and nature-based recreation and education. Our programs, many of which are led by experienced UMaine students, help Black Bears develop knowledge, leadership, communication skills, as well as an understanding of Maine's environment, ecology, fish, and wildlife. Activities range from backpacking across Baxter State Park to canoeing down the St. Croix River. Mainbound has a rigorous training process to ensure student leaders are of the highest quality and safety, and have been training leaders of our industry for generations, many of them now registered Maine guides. In February of 2020, I and a number of students from UMaine and other Maine schools spoke to this committee about the need to resolve a longstanding point of confusion as to whether the overnight primitive camping trips or paddling excursion we offer by educational institutions are required to be led by a registered Maine guide. After all, those who participate in these trips are not customers, but students who are taking an active role in all aspects of trip planning and practicing peer leadership throughout. Since then, I've been honored to serve alongside Colonel Dan Scott of the Maine Warden Service as co-chair of the Inland Fisheries and Wildlife Educational Trip Leader Task Force. I applaud the Department of Inland Fisheries and Wildlife for taking this on, especially without legislative mandate and in the midst of a global pandemic that saw record numbers of people enjoying the outdoors. I also want to thank the volunteer members who were guided by the shared principles, including setting the highest standard of safety for trip leaders and participants, only including certification of non-motorized recreation and excluding hunting and trapping, committing that trips offered under the new certification would not be for commercial purposes and would not infringe on the livelihoods of registered Maine guides, and ensuring the new certification process would not be burdensome to IFW to administer. This group worked tirelessly and thoughtfully to find consensus, and we've arrived at a proposal that is workable and that we're committed to implementing in partnership with the department and its stakeholders. I'm excited about the opportunities this process will create for our students and ultimately for Maine's outdoor recreation industry. I want to thank Representative Dunphy for her leadership in bringing this bill before you, and again recognize our incredible partners our university has in the Department of Inland Fisheries and Wildlife, and the many stakeholders who helped us get here today, including the Maine Professional Guides Association. We hope that through this new educational trip leader certification and related training, we will be creating pathways for Maine outdoor leaders of the future. I urge the committee to pass LD 1474 with any amendments recommended by the department, and look forward to being involved with the rulemaking that will hopefully follow. Thank you for your time and consideration. I'm happy to take any questions.
Are there any questions? All right, seeing none, thank you for your testimony this morning. Next is Christopher Haywood.
Good morning, Senator Dill, Representative Landry, members of the Inland Fisheries and Wildlife Committee. My name is Chris Hayward, and I represent Gould Academy in Bethel, Maine. I'm the Director of Experiential Learning there, and we've been conducting trips with students for many years, 40 or more, I believe. I'm also a Maine recreation guide and Maine raft guide, and the director of Mahoosic Mountain Search and Rescue Team here in Western Maine. It has been a pleasure working with this committee, and I applaud all involved for the collaboration, organization, and leadership of the issue. We are setting the standard here for other states to follow, I believe, with the primary goal of ensuring that all Maine students can access outdoor recreation opportunities with their schools and all of the benefits that come with that experience. Initially, we were a bit worried that we would run up against obstacles that would not allow students to access the outdoors. And I believe with this plan, we have created a way to make sure that students continue to reap those benefits and all that Maine has to offer, and pass this on to the future generations. I'll keep it brief and agree completely with what Chris and Lauren have just said. Happy to take any questions. Thank you.
Are there any questions? All right, seeing none. Thank you for your testimony. Next is Dan Walker and Karen Francois. Go ahead,
Morning.
Mr. Walker.
Yep. Thank you. Thank you, Senator Dill, Representative Landry, members of the IFW committee. My name is Dan Walker. I'm with Pretty Flaherty in Augusta, and I represent the Maine Independent Colleges Association and the Maine Association of Independent Schools. So MICA for the colleges is an organization that represents all of our private nonprofit colleges in Maine. And the Maine Association of Independent Schools is an organization that represents many of our independent schools, including town academies and boarding schools and such. I just wanted to quickly put in my 2 cents and make sure that my folks were here this morning and to give our full support about this process. I can't say enough about this process and about our participation in the process. The University of Maine system and Sam Warren approached us a while ago now about this, and then about that there was a pending issue here. I shared it with both organizations and quickly realized that this was an outstanding issue to deal with and had been kind of hanging out there for years. So I just want to thank IFW. It was a wonderful process, before, during, and after these hearings, and then during the work group. It was just a great process to get all of our folks involved. So we had folks from, and you'll be hearing from Ryan Linehan from Colby. We had Michael Woodruff from Bowdoin. You heard from Chris Hayward from Gould Academy. And then we also had Greg Shute, who's he's a very active participant on behalf of Chewonki. My role in the working group was to help with coordination and drafting, and I've already reached out and said that I'd be could be as helpful as needed when we work on this amendment to be presented at work session. So thank you again, and I'll take any questions.
Are there any questions? Seeing none. Thank you for your testimony this morning.
Thank you very much.
And Karen, you're up.
Hi, good morning, Senator Dill and members of the committee. I really appreciate your time. I'm Karen Francois. I'm a Master Main Sea Kayak Guide and an American Canoe Association instructor in kayaking, and I'm also a Master Recreation Guide. And I've been running my business, Casting Kayak Adventures, for 24 years and promoting sea kayak safety through education. I ran the Paddle Smart Safety Symposium in Bangor for 12 years, worked with the Penobscot River Keepers, and I've been running a sea kayak guide training program for the past 24 years. And I do not support the bill as written. And I think it's awesome that this committee has gotten together and talked about this, because it has been an issue that's been out there for quite a long time. In fact, I did work at Maine Bound as well. And when I was at Maine Bound, our educators were sea kayak guides or guides. So my main thing that I think is that you had an amazing committee of people, and it looks like you've done some amazing work. One group that was left out of this committee were the Maine Sea Kayak Guides Association. And we have a strong association. I don't see any Maine Sea Kayak Guides on there. So I propose that sea kayaking be added to the list of fishing, hunting, trapping, and whitewater rafting, use of snowmobiles or all-terrain vehicles as a non-allowed activity because of the essential risk on the ocean. I have concerns. There's certainly Chris and Lauren and Greg Shute and all those people that know are talking about this training program that I'm seeing is an 8-hour course. And, I've been running a sea kayak training program for the past 24 years, and there are definitely gaps in knowledge. We run a 65-hour on-water course to train guides. It's a much different environment We've seen school groups and college groups coming from inland locations of lakes or rivers and out of state are also included in this. It would be safer for their students and a benefit to the leaders if they had a registered Maine Sea Kayak guide on sea kayaking trips. Their leaders should be required to have the same intense and comprehensive knowledge required of Maine Sea Kayak guides licensed by the state of Maine. I believe that if folks are told they need an 8-hour course, they may come to believe that once completed, they know what they need to know. I can't tell you how many times I've had scout groups contact me to rent kayaks to want to run their own trips. And when I inform them what the ocean is like and how changeable it is, they end up hiring us. And it's not that I or anyone else needs their business, it's that we want to keep people safe on the water. So this is including nonprofits, scout groups, adult programs, some of the college programs. I'm totally in support of getting children in the outdoors. I was a Penobscot River keeper for 12 years. But colleges, many of them are selling their trips and there are adults that are on them.
Can you finish up in a sentence or two, please?
I can. So one of the things that I feel that was really left out of this task force was the Maine Sea Kayak Guides Association. And I do, at a minimum, I propose that sea kayaking be listed as one of the activities not included or allowed in this certification. The sea kayak industry is also a major player in promoting summer tourism and filling restaurants and lodging. And I feel that this affects our industry. And I believe it's an opening to the diminishing of the value of the guide program across the board. So I strongly feel that sea kayaking should be one of the non-allowed activities. And thank you for your time and your consideration. I believe some people sent letters. I sent mine, and thank you for taking the time to read them. And I'm happy to take any questions.
Thank you. Are there any questions? I have one. You mentioned that you thought there should have been someone from, what was it, the Sea Kayak on there. I thought there was a Sea Kayak guide on the stakeholders group.
I don't see one.
Okay. I was under the impression there was.
No one that runs a business, an outfitting business on the sea. And it's basically just the safety of the sea.
Yep. No, I hear you. I was just kind of a curiosity question.
Yeah, nobody in the Maine Sea Kayak Guides Association knew about it until Friday.
Okay, thank you. Anyone else have any questions? All right, seeing none, thank you for your testimony.
Thank you.
Linda, that's all I have on my list. Is that it? Yep. Okay, I will close the public hearing on LD 1474, an act to promote outdoor recreation opportunities for Maine students. And I will turn it over to my co-chair to start the work session, which we'll split.
Thank you very much, Senator Dill. Welcome all. I see Representative Mason had shown up here. Would you like to introduce yourself, please?
Yes, sir. Thank you, Representative Landry. I'm Rick Mason, District 56, and I represent the great people of Lisbon.
Thank you and welcome. We've got a pretty good schedule ahead of us here this morning. We have two bills, LD 89 and LD 114, both concerning the regulation of airboats. Senator Dill asked me to run this meeting since we went to an unofficial observation of airboats down in Brunswick the other day. So with that, should we start with LD 89? John?
Sure. Would you like me to go down, since the two obviously are related, I can go down through and compare them and go through so that you have the sort of a complete picture of both.
Would you please?
Okay, and I could share my screen if you want, or I'll just talk through it. You should have gotten my bill analysis this morning emailed out. Up to you, but I'm happy to do it without the screen share unless you would find that helpful.
That's fine with me if it's easier for you.
Okay. So as you know, both of these bills were concept drafts. And at the hearing, both sponsors offered amendments, sponsor amendments to replace the concept drafts with actual proposals. Both proposals are proposing temporary noise limits for airboats and the creation of a stakeholder group to examine the issue and report back next year. Obviously, the two proposals are different in a number of ways with regard to both the noise limits and also some differences with regard to the stakeholder group makeup and duties. Just one note, as you know, the current law governs noise levels for boats, motorboats, but does not apply to airboats. That's the purpose of these bills. And the current motorboat noise levels are 90 decibels under the stationary test and 75 decibels under the so-called operational test. As you also heard, there are a variety of tests out there. And those are the ones that apply to the current, again, for motorboats. What is proposed in the bill, of both bills, is actually the same for the stationary test, a 90 decibel limit at the stationary test. So that would be the same as the current law for motorboats, and both bills are proposing that as a standard for airboats for the stationary test. The difference between both bills and current law with regard to motorboats has to do with what we can call the operational test. But motorboats currently, again, are subject to a 75 decibel level for the operational test, and that's a sort of test site testing of the decibel level under sort of controlled conditions where buoys are set up and the boat passes back and forth and the meter is held within a certain distance. I think it's 50 feet of the center of the place where the boat's going back and forth. That's the current standard for motorboats. What's in the bill is, both bills, is to use an entirely different test, which is called the, basically a shoreline test. It's J1970. And the bills are different on this proposal. LD 114 would propose a shoreline test of 75 decibels, except as necessary to achieve headway speed leaving the boat launch, where the maximum would be 90 decibels. That's the nighttime standard that's proposed under 114. Again, I'm using a sort of generalized term, nighttime standard, 7 p.m. to 7 a.m. The daytime standard, which would be 7 a.m. to 7 p.m., using the same shoreline test, would be 90 decibels with no exceptions for under 114. Under 89, those decibel levels would change. Again, using the shoreline test, the nighttime level would be 65 decibels, except as necessary to achieve the headway speed, where the maximum would be 90. And the daytime shoreline test would be 80 decibels, with an exception for necessary to achieve headway speed leaving the boat launch, where the maximum would be 90 decibels. So those are the two standards that are being proposed by the sponsors for those two bills. With regard to the stakeholder group, which is the second half of both bills, both would propose creating a stakeholder group with members from DIFW and Marine Resources, harvesters, coastal residents, municipal marine officers, and coastal municipal administrators. And both would have the group examine harvester access, establishing and restoring access, mechanical adjustments to lower airboat decibel levels, operational techniques to lower decibel levels, and training and equipment for enforcement officers. Both would also direct the IFW and DMR to gather local sound data related to airboats using the various tests and a report back to both committees, IFW Marine Resources, by next year, with the committee being authorized to report out a new bill next year. The differences in the stakeholder group is that 89 would add to the group the Deputy Commissioner of DIFW and DMR as the co-chairs, one representative from an environmental organization, and one representative from a coastal or lakefront regional facility. And the examination that the group would be required to go and look at would include comprehensive survey of professional studies of the effect of airboats on coastal and inland residents and wildlife. And I would note there that DIFW did indicate that there may be a fiscal note associated with trying to do that level of a examination or survey of professional studies. So if you were to include that piece, you might want to, again, talk to the DIFW to understand the effects of that. I think that's basically what I had. Again, some complexity there with regard to the various tests. I guess the one thing I would mention is, and it's maybe worth noting, the shoreline test. I don't know a lot about it, but my understanding is that the purpose of that test is you stand on the shore and measure the decibel levels as opposed to go out and do a very formalized test. So that's why the shoreline test is being proposed for the airboats, is it's sort of from the standpoint of the listener on the shore as opposed to some sort of formalized test where you're out on the water.
Wow, yes. A lot to that. Thank you, John. Any particular questions for John or somebody going to speak to us from the department, or Representative Terrio?
Thank you, Representative Landry. As you're aware of, we did a field trip on Friday with some members of our committee, and we went down to McCoy Bay and did some of our own listening with some help from the Warden Service that had the technical equipment to do some monitoring. And I believe Deputy Commissioner Peabody has those results, and he can share with everybody else what we found on Friday.
Thank you. Deputy Commissioner, welcome.
Thank you, Representative Landry. Full disclosure, I just got him over the phone from Sergeant Mike Joy, so I have him on this little piece of paper, and he said that he would, he's going to organize them and provide them that we can put out to everybody. But so one of the harvesters, Chris Green, had his airboat there. He put 4 people on board to simulate carrying a number of harvesters out to a site. We had an ambient noise level of between 51 and 71 decibels that day. The winds were out of the north-northwest at 15 to 25, gusting at higher levels, and that was from Sergeant Joy, creating that ambient decibel fluctuation. Mr. Green did several what we call maneuvers, and primarily simulating leaving a boat launch or leaving a shoreline. And those were all done at 4,200 to 4,400 RPMs. And that's what it takes to dislodge a boat that has suctioned into the mud or up on the shore a little bit. And from Sergeant Joy was standing right at the end of the boat ramp. One of his maneuvers, Mr. Green, was 32 yards away and was at 96 decibels. Another, again, simulating leaving a launch, was 436 yards away. That was at 76 decibels. Another one at 50 yards away at 96 decibels. And one at 38 yards away was 78 decibels. And again, that's simulating, unsticking your boat and leaving a boat launch. Sergeant Joy did tell me that the 38-yard one at 78 decibels, that the wind was blowing in the opposite direction of where the boat was, so that he's accredited that with us fluctuations in some of the previous decibel levels between 96 and 78. We had another warden who was 54 yards away from the water's edge. It was up towards the main road. And during these simulated leaving the boat launch, had 88 and 86 decibels was the highest that he got from up on the, again, that's 54 yards from the water's edge. We had another harvester just show up on his own arbitrarily, and when he left the boat launch, Sergeant Joy got him at 95 decibels, and the other warden that was away from the shoreline got that person at 75 decibels, and that person was not part of the demonstration, but that's what they gave off for him for decibel levels, as they were just arbitrarily leaving the boat ramp. One of the other called maneuvers of prospecting. This was actually during the consensus-based rulemaking process. Airboat operators look for clam holes in the mud. They call it prospecting for clams. So they're cruising at a slow speed. This again was Chris Green. He was doing it at 1,800 to 2,200 RPMs on his boat. And from 365 yards away, he was 58 decibels. From 151 yards, he was 60 decibels. From 22 yards, he was 80 decibels. And 15 yards was 88 decibels. And again, this is just cruising along on the mud, quote, prospecting for clams. And so Warden Wykes, who was again stationed up next to the road, the highest level he got during this prospecting activity was 70.6 decibels. So that's all I have right now. And again, we will provide a clean version of what I just cited. Take questions.
Very good. Any questions for Deputy Commissioner Peabody? Seeing none, who else do we have here? Tim, Representative Terrio.
Well, full disclosure, my daughter lives on Wolf Neck Point down in Freeport, just so everybody that may be listening knows that I have some firsthand knowledge of the complaints that are coming from Wolf Neck Point down there in Freeport. So I don't speak out of turn. I have it from very good knowledge that the noise levels that were down there were horrendous before. It seems like last year they were much less because the Marine Service actually asked the one person that was really, really atrocious to stop participating. So his noise level is down. But I guess where this is the work session, we can just try and figure out what we're going to do. And what I'm suggesting is if we can standardize, because what we noticed in our own surveys, different boats have different noise levels. So we can't paint one brush and say this noise is going to cover everybody, because there are larger boats, there's smaller boats, there was all kinds of different boats that I saw that it's going to be difficult to stick a number on them right this minute, because I think that would be inappropriate to make everybody live under the same standard until we can standardize the boats. So my recommendation, from what I witnessed and talked to everybody, and just from what we've done so far, is that we're trying to put the cart in front of the horse. So we need to back up just a little bit and try and make sure, see if we can capture some of the federal monies coming in, and see if we can't help the boats get standardized with a grant program to alleviate as much noise out of every boat that we can, make that a standard for moving forward in the state of Maine with airboats. I think that's a much better approach than just throwing numbers out and saying you have to comply to this. I think that would be inappropriate for the clamors to even agree to that. I think they were trying to be agreeable, and I appreciate every effort they made and all of the work that they did. They actually were trying to be agreeable, but I think I don't want to paint them in a corner that they can't even themselves maintain. So I think that's inappropriate. So if we can get all of the what we've been told is that the prop pitch makes a difference. The number of blades on the prop makes a difference. There's a gearbox on the airboats. Certain ones make more noise than others, and the mufflers on the engines add to that. So there's a threefold piece of noise making that if we can standardize that and make sure that all of the boats now are running as quietly as they can, then we can do some more testing to make sure that they can do what they say they can. And then I think we can move forward. That's my thinking. It just doesn't make sense to start throwing things at the board and see what sticks. I would like it to be more fact-based. I'd like it to be a little bit better thought out than just arbitrarily throwing a number on the board. But that's where I'm at. I think there's not that many airboats. I don't think it would be a large sum of money. I think it would, from what we've roughly guessed, it would be in the $100,000 range to fix all of the airboats to a compliance level of a noise, of making sure that they're as quiet as they can be. And then we can test and find out how quiet can they be. And then we can say, all right, now you can operate in this level. And if you're outside of that level, now you're out of compliance and you're out of a job. So I think that's a good place to start. And I'm just throwing that out there and see what everybody else thinks.
Thank you, Representative Terrio. Excuse me, Representative Hepler.
Thank you, Mr. Chair. And thanks, Representative Terrio, for organizing, or whoever organized the trip. I learned a lot. I'm sort of going to go slightly in a different direction. Well, maybe sort of building on what was just said, which was to do what Representative Terrio said, but also use some of the numbers that we got and that were done as part of the consensus and the consensus rulemaking, or the attempted consensus rulemaking, which would be to acknowledge that and to use that also as sort of a benchmark. And I was thinking of the 75-90 numbers. Again, just sort of throwing that out there as well. I think it would be yeah. So there you go.
Thank you. Thank you, Representative Terrio.
And that brings up the exact point that I want to make. We heard Deputy Commissioner Peabody said they had spikes of 96 and 97 decibels, right? So they're already out of compliance. By putting a number up there, you've already made them break the law. So I just don't find that being the right direction until we can, throw a number out there, say it's 97. That was the loudest one we heard. If you want to put a number out there, because that was what we heard. If you say it's 90, 97's out of compliance. Now you've made them illegal. So that's my concern. You've actually hit on what I'm worried about. I don't think they can manage what they say they can. So I'm concerned about that.
Thank you, Representative Terrio. Representative McCray, good morning.
Thank you. Is it appropriate for me to weigh in since we're here as Marine Resource? Thank you. I really appreciate Representative Terrio's point, and that matches my testimony where I let you know that 2 of the towns I represent were very concerned about setting a decibel level. And my suggestion was if you did set one, don't go any lower than what the harvesters agreed to. But I also feel what Representative Terrio is presenting makes sense. And that speaks to the other 2 parts of the bill that I presented. The LD 114 was to continue to do stakeholder meetings, keep the discussion going, and to do some more sound data gathering. And it would, if you remember, the stakeholder group, or however you would choose to do it, would continue to look at those operational and technological changes. And I'd love the idea of getting federal funding for that because harvesters are trying to earn a living. So that, I respect the will of the committee. I just wanted to add that I understand where Representative Terrio is coming from and his statement too about the harvesters really being willing to try, and are we asking them to do something that isn't possible? Thank you.
Thank you, Representative McCray. Representative Sachs, good morning.
Good morning, Chair Landry, and thank you for the opportunity to address the committee. I so appreciate the thoughtful comments from this committee and the additional data from Deputy Commissioner Peabody. I would just say that every other watercraft, as was mentioned by your analyst, has decibel levels, which of course there are variabilities to that, right? Like currently 75 decibels are, despite so many modifications in other watercraft, have a decibel level of 75. I understand why the legislature had taken airboats out of that, and it would be appropriate to set, as Representative Hepler said, some sort of standard. I would also note that there are exceptions. The 96 and 97 that was indicated by the data from Deputy Commissioner Peabody do indicate that that is launch, and both bills do have exceptions for launch. It is those standards on the prospecting that I'd really like to bring your attention to, that many of these boats can meet these standards. In fact, that data adds to the data we already had that was proposed in '89, that 85% of those, and now that percentage is even higher, many of those boats can. I am so glad, Representative Terrio, that you also brought up what is in both bills around modifications to pitch, prop, and mufflers, which I now know an extraordinary amount, as I'm sure you do, that we never did before. These ongoing discussions, these modifications, federal money for that, as well as, I would gently suggest a professional sound study, like you said, to hopefully direct this conversation in an ongoing productive way is amazing. So thank you for your thoughtful consideration of establishing some sort of parameters. And again, I would just add that these are all, the ones in '89 are based on the data. It wasn't opinion, it wasn't a shot in the dark. This was based on the data that we had at the moment. And I'm fully supportive of that moving forward. So thank you for the chance to talk. Appreciate it.
Thank you, Representative Sachs. Deputy Commissioner Peabody, may I ask you a question?
Certainly.
Yes, you mentioned getting help from, I believe, Wisconsin in setting up some testing or insight.
I had spoken with a warden from Wisconsin and who runs airboats on the Great Lakes, and was represented to me by others that he's one of the most knowledgeable persons in the U.S. on airboats and making them quieter. I've preliminarily gave him a heads up that we may be asking him to come this summer, and that's the level of discussion with our officers and Marine Patrol officers and data gathering with some of his help and understanding the 1970 shoreline test better. That's what our department can come forward with Department of Marine Resources. Any more comprehensive study beyond what I just cited will be outside of our initial ability to absorb the cost on it.
Okay, very good. Thank you very much, Deputy Commissioner. I'll get to Representative Martin in a second, but I wanted to hear from Commissioner Kelleher.
Representative Landry, good morning. Members of the IFW committee, my name is Commissioner Kelleher from the Maine Department of Marine Resources. Happy to answer any questions. I do want to just reiterate what Deputy Commissioner Peabody just mentioned in regards to doing some additional work with the warden from out west from their sister agency. I think that it would be an excellent approach here to continue to gather additional data as it pertains to this issue. The Maine Department of Marine Resources would be happy to help cover the cost associated with that work. And I think between the two agencies, we could do that within our existing resources. The other issue of federal dollars that have been brought up by Representative Terrio is a really intriguing issue to create some additional resources to address some of these louder vessels. I think it's an excellent idea, and I am not talking yet to Commissioner Camuso, but I'm sure she would be very pleased to go to the governor's office to talk about adding that language into some other marine infrastructure spending that we're considering. And I think, as Representative Terrio said, that it would be a small amount of money. And I think if we set that up as a grant opportunity for some of those vessels, it would be another way to help address this particular issue. We testified in favor of Representative McCrate's decibel limits. I think it's incredibly important that the operational, if the committee's going in that direction, that the operational needs of the startup would be addressed, where they would, for a very short amount of time, go above a decibel limit. The 75 and the 90 decibel is the appropriate approach. Anything lower than that, I think we're going to have problems with. And if the committee decided that it was not going to go in the direction of decibel limits until we did find the information we needed through the additional studies, I had Maine Marine Patrol go talk to the one individual who was the bad actor who really was driving this issue in Freeport. And we did write him a written warning for disorderly conduct for excessive noise. And because of the amount of the sheer number of complaints that were received in Freeport, and those complaints were then transferred over to the Maine Marine Patrol. So we do have a tool on the table. It is a Class C crime. It's a little bit more than a simple civil violation, but it is something that is doable, and it's another tool that we would have going forward for this year if it was determined that the committee did not want to use any decibel limits in the short term. So that'd be happy to answer any questions, Representative Landry.
Any Representative Hepler? You're muted.
Okay, yeah, there we go. Sorry, I'm not sure this is a question for the commissioner, but I'll ask it, although Danny Martin's hand was up first.
Oh, sorry, Danny.
No, go ahead, Representative Hepler.
Well, I was just thinking about the decibel level, and now when Representative Terrio made the point that the numbers that we heard on Friday actually exceeded that at launch, and I see that both bills have a maximum of 90 at launch. And I'm wondering if there's any interest in, if we do decide to use decibels, exempt the at launch, and but everywhere else would be 75 and 90. Anyway, just a thought.
Thank you.
Yeah, I think it would have to go beyond launch, Representative Hepler, because obviously when they launch the boat, that's one time. When they stop, get out of the boat, and then start digging, that boat will create suction and get stuck in the mud a little bit. So even when they're starting up, so we'd have to identify what those operational needs are in order to go above the 95 decibel limit.
Thank you. Representative Danny Martin.
Thank you, Mr. Chair. As the Deputy Commissioner Peabody knows, this has been an ongoing issue, a long ongoing issue. And quite frankly, I like the direction that Representative Terrio is heading in. And quite frankly, since this was a concept piece of legislation, if in fact a decibel level is inserted in the bill, if in fact we move forward, I'm going to have an issue supporting that. I think we need a lot more time to look into this and see if if we can get aided by the federal folks, federal partners, and continue working with DMR and move forward with something in the distant future. Thank you.
Thank you very much. Is there any more discussion? Any more questions? Before we go any further, I'd like to welcome Representative Martin. John Martin, how are you today?
I'm doing fine. Thank you very much.
It's good to see you back here.
Thank you. Great to be back.
I'm sure it is. Good. Is there any more discussion?
I have something, Representative
Yes.
Landry, if I may. Sitting here listening, there's a lot of moving parts here, but I think what I would like to see or hear, or at least discuss a little bit more, is the possibility of turning this into a resolve and us reporting out a bill next year after both commissioners have a chance to work on this during the year, try to get funding, I think, which is going to be crucial, and go to some type of a grant program to help these airboats end up modifying. And I think we can actually talk about the three areas, which I thought I heard: the gearbox, the mufflers, and the pitch of the blades, to do those modifications, and then have them work with the airboats over the next year to see what then there may be some reasonable decibel levels. It may actually be below 90 once they've done their modifications. It might be 85 and 70 or something. I don't know what it is, but I'd like to give us a chance to work on something like that and then allow us to report out a bill next year. That would be just a thought.
Very good. Thank you. Good morning, Senator Merrimatt. You got a question or a comment?
Thank you, Representative Landry. Good morning. Yeah, I've been listening, and it seems to me the subject of this bill and conversation is at the ocean. When we're talking, it's mostly at the ocean and the harvesting there. It may be that inland there are airboats, but that their use does not generate the complaints and problems that they're causing on the ocean. So that's just note for your committee is overseeing this bill, but it seems to be about a marine environment primarily. I like Senator Dill's approach, although delaying some action a year does not speak well for the folks that are being harmed by folks who just won't correct a problem that in most cases is correctable, as he points out, because we've been talking about those three parts. The speed at the propeller or tip is a critical thing in aviation too. We developed noise abatement procedures for departures from airports. We often don't have to, but it's a good way to work with your neighbors. So we voluntarily develop them, or the airport authority develops them, and then we follow them. And that doesn't mean that you can't use all the power you have, all the speed you need in an emergency situation. But what qualifies for that in an airboat would probably be a lot less than in an airplane. So we figured out how to quiet things down and work with our neighbors. And I don't think when the problem's identified that people should have to wait another year for someone to work with them just because they can make noise. And part of the reason they're out there with this boat is to make noise. So that's the only problem. Otherwise, I think exploring those and getting the information out to the people who need it. But I suspect that those who need it already have it, and it's not a big priority. So I'm trying not to complain without a solution, but I don't have one exactly. And I see why Senator Dill is trying to get at that with this. So that's what I'm throwing out. Thank you.
Thank you, Senator. And maybe one of the solutions is to do what some of the other folks suggested, is maybe the 90 and 75, with the exception of some of the other operational needs like launching and removing themselves from the clam flats. Have that in for a year, but we still come back next year after modifications. It may stay there, it may have to raise, it may have to lower, depending on what modifications can do. So, I mean, there's a possibility to hit your decibel levels if there's a possibility.
Thank you. Representative Hepler.
Thank you, Mr. Chair. One of the things, I'm sort of going in a different direction, but just asking for information about this study. One of the things I think, Representative Theriault, that you had mentioned was also working with manufacturers for best practices. Is that right? I think that would be a good idea.
That was also one of my suggestions, yes.
Thank you. Representative Neto.
Yes, when we were there listening, it really wasn't that bad. So I'm wondering if, and I don't know who I'm asking this question to, but the person from the Harrisicke River said, well, it's much louder where he is than it was where we were. So I'm wondering if that makes a difference. Anybody?
I think McCoy Bay was a much broader expanse than where they're going up into the Harrisicke. I'm not an expert on the Harrisicke, but I'm sure there must be one. Representative Sachs.
Thank you, Mr. Chair, and thank you, Representative Neto. I would agree, the Harrisicke River, and to Senator Miramont's point, it is very different acoustics on the Harrisicke, which is why we were so grateful to have the demonstration in Freeport with many of the same folks in the stakeholder group. I would agree also, Representative Neto, that if the sound levels stayed as was done during the prospecting that you heard of 58, 60, and 80, we would not be here in the same way that we were before. There is consistent data gathered by, as Representative Theriault said, around the Harrisicke, Wolf's Neck Park, et cetera, that talk about that register far higher levels than are seen. And if they're consistently shoreline data, which is what both bills are talking about, that's incredibly important. So I appreciate the distinction. And just note that, again, this is about a watercraft. I know during this work session, you have several other noise bills coming up. For example, Bremen Lake, banning the combustion engines on Bremen Lake. This is not about banning. I think Senator Miramont's point about trying to find a level that people can live with as shared resource and good neighbors is what we are all striving for. So thank you, Representative.
Thank you. Is there any more discussion? Is there a motion? Representative Theriault.
Thank you, Representative Landry. I believe the resolve is the right direction. I really do. I'd like to see the commissioners get together and get some really good data. If we are going to put numbers on, I don't know that I like it, but I guess we can do it because the clammers agreed to it, but that wouldn't be anything I would be very happy about. But I think the resolve is the right word, that we need to go and have it looked at and see if we can get the funding. I think that's the right direction to fix the problem and then find a solution to, I just don't want to put the cart in front of the horse. And if you start throwing numbers, I think that's what you're doing. But I could live with it because the clamor said they could, so we'll see. But I think the resolve is the right direction, so.
And which numbers were you referring to? The 7590 or the 6590?
7590.
Is Representative Danny Martin?
Yeah, thank you, Mr. Chair. I could support a resolve directing both commissioners and both departments to continue working on this here. But as I understand it, a resolve would not include at the moment a decibel level, would it? I guess that's a question to Representative Terry or maybe our Senate Chair who first mentioned a resolve.
Senator Dill?
It depends on how we want to go, but whatever we do, I want to make sure that basically we also put in the resolve that we have the ability to report out a bill next year to change anything that we may do in the interim, which all we're doing here, Representative Martin, would be putting in a temporary decibel level. We can do it that way or not. I mean, it's entirely up to the committee how they want to go, but we can do it either way, is my understanding.
That was my understanding, yes.
Yeah, no, I'd be okay with that, except if we add a decibel level, the resolve might have a divided vote. Just my thoughts.
Okay. Even though if we put the decibel levels in, Representative Martin, but also exempted leaving, launch and leaving the flats where they have to, I guess, kind of rock their airboat a little bit so that they do get revved up and the sound there is much greater, as Commissioner Kelleher pointed out. And as Commissioner also pointed out, he already does have a way on any of these things, if excessive noise, to deal with it anyway. So
If in fact decibel levels are included in the resolve, that would direct the department to do something with the understanding that the resolve or the decibel levels could be modified after report back to the committee.
Absolutely.
Yeah, so the decibel level, whatever number is agreed upon by the committee, would be temporary.
It would be 1 year, and the way I would go with it personally, I would say it's for 1 year while this is getting hopefully resolved. And next year, once the commissioners have reported back to us, that's when we would, have the ability to report out a new bill. That bill could be eliminating it and just leaving it as it is. It could be some other decibel levels. So that would give us the ability at that time. So this would be just basically for 1 year in the interim.
Another question that I would have, if in fact the decibel level is included on a temporary basis, does it exempt DMR and the main warden service?
You mean on the air boats?
On the air boats, correct.
Certainly we could do that. We can go however we want to go. I'll turn it back to Representative Landry.
Commissioner Kelleher?
Thank you, Representative Landry. I'm just going to point out that a resolve would, we would not be able to have anything that would need to be enforceable within a resolve. So if decibel limits were going to be done, they would have to be done through rulemaking or through statute.
Thank you. John?
Yeah, I just kind of point out that if you do want to do the decibel levels, you could do temporary, as you were talking about. And both proposals did that, which is it puts in whatever decibel levels you choose and then repeals that on a certain date. And the bills repeals it on September 30th, 2022. So that would be a way to sort of, it goes into effect for a short period and then goes away unless you do something next year to continue it or change it or what have you.
And again, would we be exempting IFW and their airboats and DMR and their airboats?
That's a question for you, obviously.
Yeah. Representative Hepler?
Thank you, Mr. Chair. Actually, John Clark made the point that I was going to make about the current, both bills currently have a repeal in a sunset in September.
Thank you. John?
Oh, I'm sorry. I didn't mean to leave my hand up.
Okay, thank you. Representative Terrio?
Yeah, I would absolutely not have the marine resources or inland fisheries boats adhere to that at all. They would be exempt. That's my intent. I don't want that to be a concern for them.
Did you have another question, Representative Hepler?
Yes, Mr. Chair. Actually, that brings up a question. What about municipal enforcement? Brunswick has a couple of airboats.
Representative Terrio?
I'd be okay with that also.
Yes. Representative McCray?
Oh, thank you, Mr. Chair. I just wanted to comment that the idea of exceptions around launch and getting off the mud were discussed, I think, is a great idea. And you wouldn't need to have the 90 decibel cap for those. That the way the bill's written now in LD 114, the 90 is the maximum at any point, but you don't need to do that. You could make it no decibel level for those two issues while you're working it out over this year. Thank you.
Thank you. Senator Curry, good morning.
Good morning. Hello. I have a question, or to the committee. It seems like there's a lot of working on this bill and changing. I'm wondering if we're open to so it's not a motion, but I'm wondering if the committee is open to tabling while we get to the language. I would feel more comfortable if we're moving towards vote, being able to see some more specific language than just what we're talking about. But if the committee's ready there, I'm willing to deal with it at language review.
Thank you, Representative Danny Martin.
Well, yeah, just in response to Senator Curry's comments, yeah, language review is always an option, and then we can always reverse or modify that.
Thank you. Are you all set, Representative Curry?
I can follow the will of the committee on this. Yes, thank you.
Thank you. John, did you have a question or statement?
Nope.
Oh, okay. Is there any more discussion? Are we ready for a motion of some sort? Representative Terrio.
All right, I'll do it. I'm going to make a motion that we make a resolve and have the two commissioners get together. We will put the 75 and 90 decibels in there, and we'll see where it goes.
And also exempt the municipal and
also exempt all the law enforcement votes. Yes.
I'll second that.
And we have a second. John?
So I guess if you're going to put the temporary levels in, it wouldn't actually be a resolve. You'd have a bill making the change, but it'd be temporary. So and I understand what you're suggesting is these levels would be for only a period of time and then go away. And what was in the bill, or both proposals, was September of 2022, September 30th. Is that a good date for bill?
Yes.
Okay. And with regard,
and we can change it after the resolve, right?
And then yes, absolutely. So you would have the ability next year to come in, get rid of, reinstate it, get rid of the repeal, or change the repeal date, or set a different level, do whatever you wanted at that point next year. And if you didn't do anything, it would just go away entirely in September. In terms of the study, are you thinking of the sort of stakeholder group that was set up in LD 114, which would include the harvesters and the coastal residents and so forth in the group, or just have the two departments do this examination?
I guess I would ask for the commissioners to weigh in on that, whatever they feel they would like to have.
Commissioner Keller?
Yeah, I mean, I certainly would be fine with the approach that we took in the past. I haven't consulted with Commissioner Camuso on that, but it was a very good balanced group. I think they did really good work associated with that, and then we could bring in the experts to help organize that conversation. Hopefully the commissioner will agree with me.
Oh, I think that makes good sense, Commissioner Kelleher. I would respectfully request, however, that Deputy Commissioner not be the lead. I think he can certainly guide and advise as necessary, but we have a lot going on, and I believe this will probably take a significant amount of time. So I would, I think in Representative McCrate's bill, it identifies representative from the department will work, but probably not ask Deputy Commissioner Peabody to chair that committee.
Yeah, I would agree. I wouldn't want to name my deputy either. I just name the commissioner or designee.
Very good. Thank you. Representative Hepler.
Thank you, Mr. Chair. Sorry about that. One of the things we had also talked about, and I guess I wanted to double check if this is going into the resolve, to remove the caps on launching and getting off the mud, which we had talked about.
I agree.
Representative Terrio?
Yeah, I agree. I don't think there should be a cap yet. I'd like to make sure that they're able to get off the mud without having a worry.
Thank you. John?
And then the directive to the group that's doing this work, in 114, they talked about looking at harvester access, mechanical adjustments to lower the airboat noise, operator techniques to lower the decibel levels, and training equipment for enforcement officers. Would you want all of those pieces as part of this as well?
Well, I want the mechanical part. That's where the grant money is going to come from, is to take care of that. That's for sure. And then let the group decide what else needs to be added to it. If they want to add something more to it, then they certainly can, and come back with whatever they feel they want to do.
Okay, and then looking specifically for the grant funding, as you said. And then I guess the last question I had for you is the sound data. Do you want the commissioners to be looking at that sound, gathering sound data, studies from other places or whatever, or just gathering sound data as they can with this person in Wisconsin to help them out as they go forward?
I think you get an expert, excuse me, in here to help them, and he can lead them to what's the best. But I think we have our own experts enough to gather the data that we need. I thought we gathered some pretty good data, and they did some down in Freeport. That we have some numbers to work with now. Now we just got to make sure we can get the boats to comply. So I think that's the better direction. So.
And the last question I have is the temporary levels. The LD 114 had also had a stationary maximum of the 90 decibels. Were you going to include that, or just the operational shoreland test?
I don't have any comment about that one. We didn't do the stationary test that I saw, so I don't have a comment on that. But 90 decibels should cover everything, I think, other than launching and getting unstuck off the mud. So.
Are you all set, John?
So I think, so it sounds like you'd be okay with the 90 decibels for the stationary test. Sounds like, I think they meet that. And then it's the operational test, which is the 75 and the 90. And with the exceptions with no decibel level for if you're launching or getting off the mud.
For right now, yes.
Okay. That's what I needed.
All set, John?
Yep.
Senator Curry?
Thank you, Mr. Chair. I think I don't really understand how we're different than LD 114 at this point. Can someone highlight the differences between the amended motion and LD 114?
John, can you help with that? You're muted.
So the main difference with regard to the decibel levels is the 114 had a 75 decibel level during the night, with an exception for launching at 90, and there would be an exception for launching and for getting off the mud, and there wouldn't be a 90 decibel level limit there. So there'd be 75 as a general rule, but if you're launching or getting off the mud, then there would not be a decibel level. And in the daytime, the 90 decibel level would also have the same exception, which is if you're launching or getting off the mud, there wouldn't be a decibel level. And then the stakeholder group would look a little different, having my understanding is inviting these participants, the harvesters, coastal residents, et cetera, but it would be the commissioner or the commissioner's designee who would be leading that, and basically would be driven by the departments. And then what they would be looking at would be mainly mechanical adjustments, what's needed to lower the airboat decibel level, whether there's federal grant money for that, and then other issues that are related as determined by the commissioners working with the interested parties.
Representative Danny Martin.
Yeah, thank you, Mr. Chair. The reason at the onset that I brought up some reluctance and some hesitation on a temporary decibel level is because of enforcement issues. I'm looking at Colonel Peabody here, and with all the exceptions that are being proposed and what I think is going to we're going to move forward with, you know, my question to Tim would be, how are you going to enforce this? You've got exceptions for law enforcement. You've got an exception for trying to get off the mud or mud flap or whatever. You know, if I'm a warden out there, that's almost going to be impossible. But I'd like to hear some of the comments from the colonel or the commissioner from DMR as to how they're going to enforce this.
Let's go to Commissioner Kelleher.
Sure. Thank you for that question, Representative Martin. It's one that I have had a lot of conversations with Maine Marine Patrol leadership. The good thing is it's very evident when a boat is trying to get off the mud and move from a stationary position to a moving position, and it doesn't take long, 10 or 15 seconds in most cases. So with officer discretion and observation, they can tell when that boat is going to need to power up, go over that decibel limit, as long as it's not excessive. So I would chalk it up to officer experience and observation at the time to be able to then make a determination whether they would need to enforce that exception or not, whether the exception's actually been violated.
All set, Representative Martin?
Man.
Senator Curry?
My apologies, I left my hand up.
Okay, thank you. Is there any more discussion? Representative Terrio, then was that the motion to the resolve?
I believe that was, and I think Representative Hepler seconded it, so I think that.
Seconded. And seeing no more discussion, Linda, I guess we're ready for a vote.
Yes. I believe Representative Lyford is not present. Is that correct?
Correct.
We'll move to Representative Mason.
Yes.
Representative Hepler.
You're muted.
I know. Yes.
Senator Curry.
Yes.
Senator Black.
Yes.
Senator Dill.
Yes.
Representative Landry.
Yes.
Representative Terrio.
Yes.
Representative Danny Martin.
Yes.
Representative Ordway.
Yes.
Representative Alley.
Yes.
Representative Nadeau.
Yes.
And Representative John Martin.
Yes.
So that is 12 in favor.
Very good. Commissioner Camuso, did you have something you want to put in for us?
Yeah, thank you, Representative Landry. I'm just a little confused because I don't believe we can enforce a resolve. So did you just pass LD 114 or a resolve? Because I don't think we can enforce a resolve.
What I think happened was that Representative Terrio just amended LD 114.
Okay, excuse me.
And no, that's fine. Not as resolved, but amended it because the only way we could have decibel levels in there was that. That's in statute, but again, it's still temporary. So that's 114. We now have to deal with LD 89 since we're kind of hearing them both together. Is that correct, Representative Terrio? Am I?
Yeah, that's exactly right.
Perfect. Thank you so much.
Thank you. Representative Danny Martin.
Yeah, thank you, Mr. Chair. Do we need another motion to establish in statute the temporary decibel levels?
That was it then, Representative Martin. He changed it from a resolve to a straight out bill. He amended 114. He didn't make it as a resolve.
No, I did make a resolve.
Oh, sorry. If you made it resolve, then as the commissioner pointed out, we cannot have temporary decibel levels in there.
We might want to confer with John, but I think we'd have to have another a motion to place in statute the temporary decibel levels.
Yeah, if the idea is to include the temporary decibel levels, then the actual vehicle wouldn't be a resolve. I mean, essentially, you're doing the same thing as I think what you're describing, Representative Terrio, but you'd establish in statute the temporary decibel levels, repeal them at that date certain in September next year, and then have an unallocated section that directs this study to go forward. So that would be the actual vehicle for doing both of those things together. Which it sounded like was what you were wanting to do, was to actually do both of those together. So that would be done through an act, but doing exactly what you described.
All right, I guess so. Yeah, okay. I'm as confused as anybody now, so. Yeah, I guess that's what I want to do, so.
Exactly what. Do we have to revote that, or are we all set?
It's entirely up to you. I mean, I think if everyone is clear that that's what the intent is, then you're doing exactly same thing substantively. It's just a different technical vehicle.
I guess we're all set.
Yes, we're all set then. In that case, it passed unanimously 12 with one absent we'll close the work session on LD 114. And with LD 89, do we just ought not to pass on that?
Yeah, someone needs to make that motion.
Representative Danny Martin.
No, a motion has been made, I believe. I'll second the motion.
Senator Curry.
Thank you, Mr. Chair. I have a question with regard to, did LD 114 have the ability to bring a bill back? So we have that in LD 114. We don't need to put that, we don't need to create that vehicle.
John?
Yes, that would be correct. That'd be part of the stakeholder group process. Or when that group came back next year, you would have the authority to report out a bill in response to that. So you wouldn't need a different vehicle.
Great. Thank you very much.
Any more discussion on LD 89? Seeing that, Linda?
Can I ask who made the motion? I got the second, but not the first.
Who made the initial motion?
Yes.
I did.
Thank you. All right. So again, starting with Representative Mason,
Yes.
Representative Hepler,
Yes.
Senator Curry,
Yes.
Senator Black,
Yes.
Senator Dill,
Yes.
Representative Landry,
Yes.
Representative Theriault,
Yes.
Representative Danny Martin,
Yes.
Representative Ordway,
Yes.
Representative Ali,
Yes.
Representative Nadeau,
Yes.
and Representative John Martin.
Yes.
Okay, so again, 12 in favor, 1 absent.
Very good. We'll close the work session on LD 89, 12 in favor, 1 absent. Thank you all. That's been a very educational session. We have another bill coming up, LD 349, an act to prohibit the use of personal on Kai's Pond in the town of Sweden. Yes, Linda?
Yes, the Representative Millett is in 2 other meetings this morning, and that was listed as last. I told him that I would email him before we started it. It's listed on our schedule as being last.
Okay, thank you. Then we can move on. John?
Yeah, I mean, certainly, however you wish to go, you do have the 3 ATV related bills, 944, and then 1244 and 1439. So if you wanted to take up 944 next, you could do that.
And we also have Representative Fay, who has a couple of the meetings she wanted to get in with her Wildlife Rehabilitators Act. We could slide in before the 3.
Yes.
If it's not a problem. Senator Dill?
Oh, go ahead. LD 1012.
Okay. Yeah, where are LD 1012? You want to take that? You want me to?
Nope, go ahead.
Okay. John, what do you have for us on LD 1012?
Sure. So this is the bill, an act to fund wildlife rehabilitators. And the original bill would create a new project category under the Outdoor Heritage Fund for wildlife rehabilitation, and then make some adjustments in the Outdoor Heritage Fund to provide funding for that new category, again, adjusting the other categories that are already in the Outdoor Heritage Fund. As you heard before, the Outdoor Heritage Fund can provide funding to wildlife rehabilitators under so-called Category 3. It is limited in some respects. It's not all wildlife rehabilitators. They have to be working with endangered, threatened, or species of special concern, but they can and have gotten grants under the Outdoor Heritage Fund. I guess a couple of other notes before mentioning the amendment that you have from Representative Fay. There was a question at the hearing about whether the Operation Game Thief could get money from the Outdoor Heritage Fund, and the IFW has indicated that under Category 4, they would be eligible. They're not aware that they've ever applied, but they would be eligible under that category. And as you know, the funding source for it currently for the Outdoor Heritage Fund is a portion of the lottery receipts, and also they can receive money from any other public or private sources. So Representative Fay's amendment, which you should have received, would replace the bill and not create a new category under the Outdoor Heritage Fund, not change anything in terms of the division of the funding. It would simply provide $75,000 in each year of the biennium from the general fund to the Outdoor Heritage Fund. Again, not limited to wildlife rehabilitators. It would be for the whole program. And again, the wildlife rehabilitators could apply under category 3. And if they were accepted, they would get it in the normal course. So again, her amendment is just to provide $75,000 in each year of the biennium to the Outdoor Heritage Fund and replace the bill entirely. So there would be no new category or change in the Outdoor Heritage Fund.
Thank you, John. Representative Danny Martin.
Yeah, thank you, Mr. Chair. A question to John. Currently, in the statutes, it indicates that that group is funded by sales of lottery tickets. So does the proposed amendment clarify that, or does it just supplement the sale of lottery tickets?
It would supplement. The fund in statute receives, as you mentioned, the majority of its fund from the lottery. It also is allowed to receive funds from any other public or private sources, and this would provide another public funding source to the fund.
Clearly, also, just for the committee members, this clearly will go before the Appropriations Committee if general funds are included, correct?
Yes.
Yes. Thank you. Anyone from the department want to speak on this? Commissioner?
I'd move on to pass as amended.
Okay, we have a motion. We have a second from Representative Hepler. Oh, you have a question or a second, Representative Hepler? You're muted.
Second.
Second, okay. We have a motion and a second on the amendment to Bill, where are we? 1012, an act to fund wildlife rehabilitators. I have a question. Representative Fay, do you have anything you'd like to add before we go ahead?
Well,
you're muted.
Thank you, Representative Landry. I appreciate that. Yeah, I spoke, this was the bill, I don't know if folks remember, this is the bill where we had the Girl Scouts come in, and I've been working on this with them for a while. And I'm, again, really proud of the work that they did in bringing this forward. I think one of the things that we recognized and we heard during the public hearing was that the Outdoor Heritage Fund could use some additional resources in order to fulfill the grants that it was receiving. And so I chatted with the girls, and we recognized that if there were increased funds in the fund for additional grants, that could really help those rehabilitators that were working with these specific populations of animals. So they seemed all for that. They didn't promise that they weren't going to try to come up with something else and come back to you someday. But if that happens and I'm around, I'm certainly going to help them do that. But I think this is really a worthwhile use of these funds, because the work that the grantors from the Outdoor Heritage Fund do in all of our communities is really good work. And I'd also like to point out that, and I don't have the history as much as other folks on this committee do, but I believe George Smith was also one of the folks that really helped start the Outdoor Heritage Fund. And it occurred to me that it seemed to me that this would be a good proposal at this time. So we'll work with the Appropriations Committee to see if we can get this funded off the table, but I'd appreciate the vote of confidence from the committee just on the policy piece, and we'll see if we can figure out the funding piece once we get to the table. Thanks.
Well, thank you very much, and we appreciate it. And again, thank the girls for such a great presentation that they did, and I hope they can watch what we're doing here today. Representative Terrio?
Yes, thank you. I agree. I love a lot about it. I really do. I think the girls did an amazing job of representing what the cause is, and I have no problem with the cause whatsoever because, like I said earlier, I think it's very, very good. I have an issue with it coming out of general fund money. I really do, unfortunately. But the concept I love, and I wish the girls would take it up as a fundraiser on their own. That I would support 1000%. But right now I'm just not there with the funding from the general fund, unfortunately. So I'm sorry.
Thank you. Is there any more discussion? Seeing none, I guess we're ready for a vote. Linda?
Yes. Representative Mason,
No.
Representative Hepler,
Yes.
Senator Curry,
Yes.
Senator Black,
No.
Senator Dill,
Yes.
Representative Landry,
Yes.
Representative Terrio,
No.
Representative Danny Martin,
Yes.
Representative Ordway,
No.
Representative Alley,
Yes.
Representative Nadeau,
No.
and Representative John Martin.
Yes.
So that's 7 in favor, 5 against, and 1 absent.
Okay, with that, then we'll close the hearing on LD 1012.
Can I just ask?
Go ahead.
I just asked what the minority report is. Is that ought not to pass? Ought not to pass.
Okay.
The minority report. Okay.
Okay, close the hearing on LD 1012, an act to fund wildlife rehabilitators. 7, 5, and 1, I believe was the vote. Thank you all. Senator Dill?
Yeah, go ahead with 944, and then the next one after that is yours anyway, so we'll just flip over then. So you go ahead.
Okay, we'll open the work session on LD 944, an act to simplify dual registration of snowmobile and all-terrain vehicles. What do you have for us on this, John?
So as you say, this is a bill that would allow for the dual registration number for an ATV that is also capable of being equipped with tracks and used as a snowmobile, so-called tracked ATV. The annual fee would be the combined total of those two fees. The dual registration stickers would need to be clearly displayed on the front and rear of the vehicle, and the registration would be valid for the same period as the ATV registration. As you heard from the DIFW, it is currently possible to currently register an ATV both as an ATV and as a tracked ATV at the same time. It just needs to be a separate registration, but you can do it at the same time, and both are valid for the same period. They both expire at the end of June. They had indicated an administrative burden of creating the new combined registration, and you do have Brian Bronson from the ATV, or who is the ATV program supervisor, who's available from the Department of Ag to talk to you about some of the concerns that they have if you would like to hear from him. One of the things that had been mentioned is worth just pointing out was right now, as you know, an ATV registration fee, portions of it are dedicated to certain funds. The snowmobile registration fee, portions of that are dedicated to special funds. This combined registration would not go into those funds as it's set up. It would appear to default to the general provision, which would allow the cost to be used, those fees to be used for administrative costs and deposit in the general fund as well as a distribution of a portion of it to the ATV and snowmobile fund. So it would be a different distribution of funding based on the fact that it's a combined registration as opposed to individual, at least as it's currently drafted. And that's what I had.
Any questions for John? Anyone want to speak for the department? Brian Bronson?
Can you hear me?
Yes.
So again, generally our response was that we feel this practice is problematic because it's basically circumventing the ATV law, which requires landowner permission, and that people who register their ATVs as snowmobiles in some cases are going on landowners who otherwise wouldn't allow them to go with an ATV. And so we've never felt, this was talked about at the governor's task force last year or 2 years ago now, I guess, but that this was a practice that probably wasn't maybe the best practice. And we just didn't feel like making it a more fixed, easier practice would just tend to encourage more people to do this, which might create more problems for the landowner. Obviously, it does, as written, reduce both programs' funding as well. So that's why we were opposed to it.
Thank you. Representative Danny Martin?
Yeah, thank you, Mr. Chair. Mr. Bronson, for the record, since people are listening, could you introduce yourself?
I'm sorry. My name is Brian Bronson. I'm the supervisor of the ATV program, the Bureau of Parks and Lands at Agriculture, Conservation, and Forestry.
Yeah, thank you. Mr. Chair, could we hear from Mr. Swan? I believe they had some opposition as well. Am I correct?
Yes, they did, certainly. Mr. Swan?
Can you folks hear me okay?
Yes, we can.
Okay. So I'm Bill Swan, Director of Licensing here at Inland Fisheries and Wildlife. Our basic opposition to this is that currently people are already capable of registering a tracked ATV as both an ATV and a snowmobile. They can do so at the same time if they want to. They can do so at separate times during the year if they want to. Most people actually do it in separate times during the year as is. So we just feel that this is an unnecessary complication, not only for us, but for our agents. So if you can imagine, the town offices dealing with this and on a very low volume basis, so they'd have 1 or 2 a year possibly, and they would be most likely confused about how to handle it. Okay, so that's our basic thing. We'd have to come up with a new set of sticker, a new sticker type and distribute those to the agents and on and on. So that's our basic opposition.
Thank you, Representative Terrio.
Thank you, Mr. Chair. I was originally supportive of this. I thought it was a really good idea, but when we're talking about taking monies away from trails and any other thing like that, complications that it's caused, the more I hear, the more I don't like it. So I have a lot of concerns.
Thank you. Good morning, Representative Schofield.
Good morning, Representative Landry. Good morning, everyone. My name is Tom Schofield. Thank you for allowing me to interject here. I appreciate that. It was never the intent of mine, at least, when I introduced this, to change the funding formula. It was going to be just solely administrative, journal money to the snowmobile side or to the ATV side, however it was, which I think can be done. But if the department finds it is cumbersome, I suppose I can understand that as well. It was just a matter of public service. And one of the issues, and perhaps the department isn't aware of this, one of the issues, I contacted a number of town offices in my district, and one of the problems is if you do have an ATV with tracks on it, and you use it in the winter for snowmobiling purposes, which is a legitimate use, you can't go to the town office and buy both of those registrations at the same time. You can buy the ATV registration in the summer or July 1st or whatever, but the department doesn't issue the snowmobile registrations until later in the year. So it is not one-stop shopping, as I understand it. The department says you can go and buy them both at the same time. Well, you can't. You have to wait several months. So if you're in a position to spend your money and do it both at the same time, it's my understanding that's not always the case. So I guess if nothing else, I would urge the department to make sure their registrations and their stickers are available at the same time for both of these ATVs and snowmobiles, and not force the individual who wants to register it as a snowmobile to have to come back to the town office perhaps some months later to do that. So it never was the intention to complicate things. It was intention just to make it more customer friendly for the folks who do have these. I understand there are a few hundred of us out there, and perhaps as time goes on, there will be more. And if the department then feels that they can be more customer friendly and issue a third sticker for those who request it, perhaps as time goes on, they may address that. Thank you very much for your consideration. I appreciate it today. Thank you.
Thank you, Representative Schofield. Mr. Bronson, did you have, I see you're unmuted. Okay.
No, I'm fine.
Okay, thank you. Is there any more discussion on 944, LD 944? Representative Terrio.
Yeah, I'd like to make a motion not to pass.
We have a motion not to pass. Do we have a second? We have a second from Representative Alley. Any more discussion? Seeing none, would you call the vote, please, Linda?
Before you do, I don't know if Representative Schofield has his hand up or if it was just left over from before. Representative Landry.
I am sorry, I didn't mean to have my hand up, but once again, I would urge the department to make sure that the stickers for both vehicles are available at the town offices and not have a long delay between the ability to issue a registration for an ATV and then folks have to come back some months later to register it as a snowmobile. And I apologize for leaving my hand up, but I'm glad I did. Thank you.
Okay, thanks again.
Then could Bill Swan answer that question if there is a delay, or do most agents have the stickers at the same time?
Yeah, okay, so a couple of points on this. I guess the first point is folks are able to register both ATVs and snowmobiles online. So they can go online at any point, after May 1st, if you will, and they could register for the upcoming year, okay? And they could do both machines at the same time. So that's number one. Number two is, it is true that we do not currently distribute snowmobile registration stickers to the town offices until typically early September. The reason that we don't do that is that there really is, in general, no demand for that. And sometimes things kind of go missing or get mixed up or whatever if they're not immediately being used. So that's really the reason that we have never distributed snowmobile stickers to the towns until September. We could certainly do it in the spring if that was something that was really necessary, but we would prefer not to, because we like them to have them readily on hand when the demand is really there to have them.
Thank you.
Thank you. Is there any more discussion? Yes, Representative Terrio.
Yeah, so that makes a good point. So if you do have internet access and you can go online, you can register them both at the same time. And then you just wait for your stickers whenever they come. Is that what I'm hearing?
That is correct, yes.
Representative Ordway.
Yes, Mr. Swan, any idea on the numbers, how many people do it online and how many people actually go into the town halls?
Yeah, that's been growing significantly. We're registering, anywhere from 20 to 30,000 of each vehicle type online, and it's growing significantly every year, and certainly grew very significantly last year as the town offices, were closed or running limited hours because of the pandemic.
So I can't go in May 5th to my local town office and register both at the moment. Even if I wanted to pay the money and they would not mail me the sticker once they got it. Is that correct? That if I went into my town office May 5th, said, hey, I'm here, I got my money now because I just got my income tax back. So I want to register both these vehicles while I got the money. And you say, sure, but I can only do the ATV, and they take the money for that and hand you the sticker, but they wouldn't take my snowmobile registration because they don't have the stickers. Is that correct?
That's correct. The other slight technicality here is that currently right now in law, which we have a provision in to change, is that snowmobile registrations for the upcoming year by law don't start until June 1st. Now, the department actually wants to move that back to May 1st so that it is one date, and it isn't, there aren't two dates floating around.
Okay.
Thank you. Are there any more questions? See on Linda, would you call the roll?
Be happy to. Starting with again, Representative Mason,
Yes.
Representative Hepler. Is she still here? Representative Hepler? She must be away from her mic. I'll be back to her. Senator Curry.
Not to pass, yes.
Senator Black.
Yes.
Senator Dill.
Yes.
Representative Landry.
Yes.
Representative Terrio.
Yes.
Representative Martin.
Yes.
Danny Martin. Representative Ordway.
Yes.
Representative Alley.
Yes.
Representative Nadeau.
Yes.
And Representative John Martin.
Yes.
Representative Hepler. She has
Still
stepped
missing.
away. Okay. Well, then that makes it 11 in favor and 2 absent.
Very good. We'll close the work session on LD 944, an act to simplify dual registration of snowmobiles and all terrain vehicles. Ought not to pass, a vote 11-2.
All right, the next one up is yours, Representative Landry. So I will open the work session on LD 1244, an act to extend electronic proof of registration to all terrain vehicles, snowmobiles, and watercraft. So John.
So again, this is the bill that would, as you say, would allow a person to present or have available for inspection an electronic form of registration, certificate, online registration receipt, or certificate of number for a snowmobile, watercraft, or ATV. And as you heard at the hearing, DIFW has been since 2015 allowing that electronic form for hunting, fishing, and trapping. And apparently that has been going fine. So they're supportive of extending it to the ATVs, snowmobiles, and watercraft.
Great. Are there any questions for John? Seeing none, I guess I'm ready for a motion. Representative Danny Martin.
Thank you, Mr. Chair. Move on to pass.
Is there a second? Seconded by Representative Alley. It's It's been moved and seconded. Any further discussion? Seeing none. Linda, would you call the roll, please?
Yes, perhaps starting with the other end of the horseshoe this time. Representative John Martin,
Yes.
Representative Nadeau,
Yes.
Representative Alley,
Yes.
Representative Ordway,
Yes.
Representative Danny Martin,
Yes.
Representative Terrio,
Yes.
Representative Landry,
Yes.
Senator Dill,
Yes.
Senator Black. Has he left us? Senator Black, are you there? No, we'll come back to him. Senator Curry,
Yes.
Representative Hepler. I think she's gone to a work session. Representative Mason.
Yes.
And okay, so we'll try back again. Excuse me, Senator Black. Okay. So that's 10 in favor and 3 absent.
Okay, ought to pass on LD 1244, an act to extend electronic proof of registration to all terrain vehicles, snowmobiles, and watercraft. 1003, so that one passes. We'll wait to hear from the other 3. Moving on to I'll close the work session on LD 1244. And I'll open up the work session on LD 1439, an act to clarify all-terrain vehicle registration requirements and establish regular maintenance of designated state-approved all-terrain vehicle trails. And that is Representative Terrio's bill. So John, would you start, please?
Sure. So you got 2 things from me in the email. One was bill analysis and one was a side-by-side. The side-by-side might be the easiest thing if you're pulling one up or looking at it to use. And I'll go down through basically in the order in the side-by-side. I tried to order them as opposed to the way they're in the bill because of, sort of numerically more by subject area. So it's a little bit out of order from the way they are in the bill. So the first thing, I guess it's important to remind you that the committee last year had 2 bills, one a committee bill, LR 3280, and also LD 2130. The committee had voted to amend 2130 and report it out, and had voted to report out the committee bill LR 3280. And those 2 bills as amended and produced by the committee, even though they died last year because of the pandemic, are essentially what's put forward in this bill 1439. There's some minor changes, basically date updates, but essentially it's what was in those 2 bills. And as I go through, I'll just mention which bill it comes from, each section. So first up is Section 7 of the bill, and it increases the registration fees, and those increases, $25, all of that goes into the ATV Recreational Management Fund. This would begin May 1st of 2022. That's the effective date for those fee increases. Section 10 of the bill, and that was from 2130, LD 2130 as amended by the committee last year. Section 10 of the bill requires the department to review the ATV registration fees in 2022 and 2023 and every 2 years thereafter, and to report to the committee. That was from LR 3280, the committee bill last year. So going back to section 1 of the bill, there are several sections, sections 1, 2, and 3, which relate to the use of the ATV Management Fund. They clarify that the fund can be used only for the acquisition and maintenance of state designated ATV trails, just making sure that it references the state designated or state approved trails. It requires annual maintenance, use of best practices, and allows the fund to be used to ensure annual inspection of the trails. That was both from LR 3280 and from the amended version of 2130 from last year. Again, all from those bills. Section 4 of LD 1439 comes from LR 3280, the committee bill last year. This is the section, actually section 9 relates to it, relating to antique all-terrain vehicles, allowing them, these are vehicles that are more than 25 years old, allowing them to be registered as an antique ATV, and the fee for that is $33. All of that fee would go into the Recreational Management Fund. And here, just note, you heard from IFW, there may be a fiscal impact associated with this section that you might want to discuss. Currently, as you know, a portion of the ATV registration fee goes to both the management fund and to the ATV enforcement fund at IFW. This antique registration would go entirely to the recreational management fund. So to the extent there are a large number of antique ATVs registered as antiques, it would change where money's going. And that could have a fiscal impact on the department. So just note that for you. I know the department has some more information they can provide you on that. The section 5 of the bill, we're shifting now to operation of an ATV. This is from LR 3280, the committee bill last year. Currently an ATV, an unregistered ATV, can only be operated on land that the ATV operator lives on, or on land on which the owner is domiciled. And this changes it to provide that can only be operated, is again, unregistered ATV can only be operated on land that the ATV operator owns or leases, regardless of where the operator is domiciled. And that, I just pause here. It's an important piece in understanding a couple of the other things in the bill. This is a complete limitation. So if you are an unregistered ATV, that's the only place you can operate. It's expressly says there you're not allowed to operate anywhere else. If you are registered, then you get the privileges to go elsewhere. If you're unregistered, you're limited to the land you own or lease for operation. The bill in section 8 creates a new oversized ATV category. This is from LR 3280, the committee bill. These are the ones that are over 65 inches wide and over 2,000 pounds. These oversized ATVs would be grandfathered for the purposes of registration if you're a resident who registered that oversized ATV before, and the date here is January 1, 2022. Again, that's an adjustment from last year's bill, just updates the date to last year it was August 1st of 2020. This one changes it to January 1st of 2022. Again, that's a grandfathering for the oversized ATV registration, and you have to be a resident, and you have to have had that ATV registered before that date of January 1st of 2022. The next section, section 12, and this is relates back to what I was just talking about with the registration or unregistered vehicles and where they could go. This provision is from the committee bill last year, 3280. And I'm not absolutely sure what it does or what it's supposed to do. So I highlight it for you. It says that is except as prohibited, a resident may operate an oversized ATV on frozen bodies of water. Because of the requirement that, or the limitation that if you have a unregistered ATV, you cannot operate anywhere else than on your own land. This provision, if read in concert with that, would seem to indicate that the only resident that can operate an oversized ATV on frozen bodies of water would be a resident that had a registered ATV. If it's registered, they could already operate on a frozen body of water. So it's not clear what this provision is doing. If it's intended to do something different from that, it would probably need to be amended. If it's only intended to allow registered oversized ATVs to be operated on frozen bodies of water, it could probably be eliminated because that would be already allowed if you're registered. So again, that's for your consideration there. I'm not sure that that section actually does anything as written. The next section, section 11 of the bill, again from the committee's bill last year, LR 3280, clarifies that a landowner can limit the use of an ATV on trails on their land, including limiting the size and weight. And as you heard, that was different from the task force requirement. This also would make it permissible for the oversized registered ATVs to be operated on the state trails, and that's different from the task force recommendation. But it is consistent with what the committee decided last year. The last couple of sections, section 6 of the bill, again from the committee bill last year, 3280, requires the registration agent to explain the limits on the oversized ATVs. And section 13 requires the dealer to explain the limits on the ATV or oversized ATVs. One note here is the department had indicated that it would prefer if it didn't require the agent or the dealer to provide the explanation orally, but rather have IFW prepare an information sheet and have those people hand out the information sheet so that it was one set of information rather than an oral presentation by the dealer or the registration agent. The last section, section 14, which actually is not from either bill. It was sort of implied, I think, in those bills, which is it specifically directs IFW to develop the educational component for dealers and owners and agents regarding the operation and registration of oversized ATVs. One last note, and this relates to the dealer requirement to provide the information about oversized ATVs. Last year, that section was put in a different section of law, which has a penalty associated with it. The section that this is in doesn't have a specific penalty. I don't know if that's a significant issue for the committee, but if the section that it was put in last year, 31-161, has a civil penalty of $100 to $500 if the dealer does not meet the requirements of that section. So if the dealer hadn't provided the information on the oversized ATVs, they would be subject to a civil penalty. The section that's in the bill, that penalty wouldn't apply. The same requirement is there, it's just that the penalty would not apply. So if you want that penalty, we could just shift it over to the other section. At the end of, I don't know if you've got it in front of you, but at the end of both the bill analysis and the side-by-side, I've got a little table that shows where you can ride if you're registered or unregistered. And as the bill is currently worded, as I read it, it's exactly the same whether you're an oversized ATV or a regular ATV. If you're registered, you can basically ride it in places where registered ATVs, whether you're oversized or undersized. If you're not registered, then you can only operate it on the land you own or lease. So that's what I've got. I know there's a lot there, and I'm happy to go over any portions of that or answer questions.
Representative Neto.
Yeah, I just want to make sure I get this clear that if you drive your ATV, which will have tires on it, on the lake, you don't need to register it. But is that correct?
If it's registered.
Oh, so you do have to register it to go onto the lake?
Yes, under the current law and under this bill, the only place an unregistered ATV can be operated is on the land you own or lease.
Okay, all right.
Yeah.
Yeah, that makes sense.
And the ability to go on the ice is, I mean, there may be other limits if, you know, the area is off limits or something, but except there's some specific prohibition, you can go on the ice if you're registered.
Okay. And the other thing is about the weight limits. I know some people said that their ATV was already over the limit. So if they wanted to sell it, they couldn't sell it to anyone in Maine, I guess.
They could sell it, but they would not be the person who purchased it couldn't register it. So then they would only be limited to operating it on their own land.
Yeah, that I think could be an issue. I mean, it would be for me if I were. And then the dealers that already have these vehicles that are over the weight limit right now in their shops, they'd be kind of stuck with them. Just thinking out loud. That could be an issue. That's all I have.
Representative Ordway.
I'm trying. Here we go. Yeah, John, I'm a little bit confused on the wording on the oversized. Let's go with, I thought the original bill from last session allowed oversized to be used only on landowners or land with permission or their own land, and on the ice, both to be registered, and not on the trails. I think that the issue with the oversized to me is two of these aren't going to fit on most of our trails passing. So I'm a little confused the way you explained that. If you could just go back to that for a second.
Yeah, so with regard to the trails, that's, you're putting your finger on the difference between what came out of the committee's bill last year, as I understand it, and what the task force had earlier suggested, which was, I think the task force has suggested that the oversized ATVs registered, including the registered ones, should not be allowed on the trails. This bill, which I believe replicates what happened last year, says doesn't prohibit the registered oversized ATVs on the trails, but does provide that the landowners whose trail it goes over, the trail goes over, can limit the size and weight. So the landowner could be the one to say, I'm not going to allow the oversized, but the law itself wouldn't prohibit the oversized ATVs on the trails.
Senator Black.
Thank you, Mr. Chair. I'm a little confused because all oversized will not be able, when this law passes, to be registered, I believe, from here on out. And in the past, if I'm correct in my thinking, they have been allowed to go on private property, which they'll continue to be able to do with permission, but they won't be able to go on frozen waterways. Is that what I heard with the new law?
So the oversized ATV under this bill, if you already have one and it's already registered, then your grandfather, you can continue to register that. So those would continue to be allowed, and those would be you would be able to operate them just as you would be able to operate any other registered ATV. Anybody else who had an oversized ATV would be limited to operating on their land.
Representative Terrio.
Thank you, Senator. I'm a little bit dismayed because I was part of this last year when we talked about it, and I don't remember us changing many things. I remember us adding that an unregistered ATV could ride on a frozen body of water, and that a landowner had the right to say who could ride on his trail that goes through his land. That is the only things that I remember changing from the task force. So where all this other changes are coming from, I don't know if the revisers have done it, or I don't remember us doing any of what these things are saying we've changed. We talked an awful lot about it. And I remember us changing, saying that if you owned an oversized ATV, you could ride on frozen water unregistered, and a landowner could say who could ride on his trails that are on his land. And I do not remember us changing anything else. So maybe I'm wrong, but I got to tell you, we talked an awful lot about this stuff, and I don't remember us deviating much from what the task force wanted.
So starting May 1st next year, 2022, if I walked into a dealership and I wanted to buy a large ATV, an oversized ATV by what our dimensions are here, I could buy it, but the only place I could use it would be basically on property owned or leased by me. But I could not register it at all. However, if I've got one that's already registered, I can use that wherever because it's grandfathered. Is that correct to that point, John?
Yes, exactly. And I just wanted to also mention what Representative Terrio was saying about the unregistered ATV on frozen bodies of water. If that's the intent, and this language was from last year, so it isn't changed from last year, but that may have been incorrectly drafted last year if that was the intent, because that's not what it says and not what it actually said last year in terms of the actual drafting. But
well, that's what I'm getting at. That was the intent. I remember the sponsor saying it. That was the only intent, was to allow an unregistered ATV to be able to ride on your own land or on a frozen body of water. Those were the two places that I remember. So whether they got written that way, I don't know.
So also continued on the other question that I had, John, or the same vein, is that, okay, so my oversized ATV is grandfathered and I can register it and continue to register it, but I can never sell it basically to anybody in the state of Maine because then they couldn't register it.
Yeah, that's a problem.
Is that, yeah, I kind of see that as a problem too, as Representative Neto had said earlier, that I would think if it's registered to be used in the state of Maine, grandfathered, if I wanted to sell mine to Representative Martin, then, you know, Representative Martin, as long as that has been registered in Maine, should be able to continue to use that until that machine is no longer usable. I'm just kind of thinking along those lines. And the next one in line here is Representative Landry.
Yeah, it seems though we did pass it that way, that you couldn't transfer the registration. But
Right.
I guess my biggest concern is the allowing oversized ATVs on state trails. That I thought was the heart of the whole thing.
And we still aren't, I guess. Even a registered vehicle ATV would not be allowed on a state maintained rail. I mean,
Good.
trail. Representative Ordway.
Yeah, and again, I'm an old man and I don't remember things, but I don't remember saying that unregistered could operate on a body of water. I think it was the limitations where we put on state trails that they couldn't ride on state trails, but they could register it and ride on open bodies, frozen bodies of water. That's the way I remember it.
Yeah,
I never remembered no registration.
No.
that was a Representative Stearns push, I thought. Maybe that was with snowmobiles, but I know he really pushed for the frozen bodies of water, and that's how it got put in at the very end. Representative Martin, well, I'm sorry, go ahead, Representative Ordway.
Yeah, no, I pushed for that they would be allowed to do the oversize on a lake or frozen body of water, but I don't. It's the not registered part that
right
To me, they would have to be registered to be out on the lake. If a snowmobile has to be registered or a pickup truck has to be registered, then certainly an oversized ATV should have to be registered.
Chairman, I
Yes.
wonder if maybe John could take a look at the legislation, because we actually voted for it on the committee. We adjourned, so we never went anywhere with it. But take a look at and go back to that original draft.
Okay. Do you have that there, John?
Yes, and that thank you. That's the language that was actually the final, quote unquote, final language from last year. Simply said that an oversized resident can operate an oversized ATV on a frozen body of water. That, together with the other provision which says if you're unregistered, you can only operate it on your own land, I think means that if you're going to operate the oversized ATV on a frozen body of water, you have to be registered. I don't want to say that I know that was the committee's intent, because I wasn't working with the committee at that point, but the language itself, read in conjunction with the other existing language, I think meant that, said that. Before the language, and it is the same language in this bill, the result would be only a registered ATV would be allowed on the ice. And again, to the extent that's the intent, you actually don't need to say anything about that, because if you're registered, you would be like any other registered ATV, allowed to go where a registered ATV is allowed to go.
Representative Danny Martin.
Yeah, thank you, Mr. Chair. My recollection of that discussion, which was unanimous, by the way, when we met, I believe in July, was that the only option that one could go in a frozen body of water is if the individual owned a cottage by lakeside and not utilize trails to go to that frozen body of water. And that was my recollection.
Deputy Commissioner Peabody, would you like to weigh in here?
Yeah, thank you, Mr. Chair. Deputy Commissioner Tim Peabody. John's analysis is, in one sense, the way the law is exactly right now. If you're going to be on a frozen body of water, you need to be a registered machine. Colonel Scott has a presentation on if you have unregistered machines on the frozen bodies of water that make me pay attention. And I think if the committee wants to go down that road, that they need to hear of the enforcement issues by allowing an unregistered ATV on a frozen body of water.
So right at the moment, Deputy Commissioner, if I owned a cottage on a pond, a lake, doesn't matter, and I had a beater snowmobile, I couldn't take that out on the lake and go fishing or riding on the lake if I wanted to, if it's unregistered. Is that correct?
That's correct.
Okay. Thank you. Senator Black.
So my question is, what kind, I mean, wouldn't, if the new oversized one would have to have registration to be on the lake, would that be wouldn't that be confusing, or would you have some kind of another type of sticker? Because you don't want it to be part of the grandfathered group, and you don't want the sticker to allow it on trails, but it has to be registered to be on the lake, I guess. So I'm a little confused how you would enforce that. I don't know if the Deputy Commissioner could address that.
Yeah, currently, the way the law is worded, if you have an ATV and you only want to operate it on your own land, this is where some of the confusion was. Current law right now, if you only want to operate it on your own land, you don't have to register it. But that doesn't allow you to take it on a frozen body of water to go ice fishing. That's the way it always has been, and the way that it is right now. The discussion about allowing unregistered machines in a different manner, that we're discussing here is where the enforcement challenge comes in. And if you want a full dissertation, if the chair would like Colonel Scott to weigh in on it, that would be my recommendation.
Can I follow up, Mr. Chair, first?
Sure.
Deputy Commissioner, just help me understand though, and I fully understand what you just said, but my question is, with the new ones that are going to be registered, not grandfathered, so they won't be registered at all from here on out. They won't be registered. That's okay. I guess they can't be registered if they're oversized, and so if they can't be registered, they can't go on to the lake. Okay, I'm starting to forget right now.
That's correct.
Thank you.
But it's the same actual way the law is written right now. You ride it on your own land, but you won't be able to ride it on.
So those large ATVs will be always barred from frozen water. All the new ones sold.
Going forward, and that part of the bill is that the person would be advised of that when they bought it.
Thank you.
Representative Terrio.
Thank you, Senator. Yes, and I just got off the phone with Representative Stearns, and I was correct. That was the intent of the bill, but it wasn't the best intent, and we need to get rid of that. Because that was what his intentions were, was to not have it registered on frozen lakes. And I told him that's not what we were going to do. So he said, well, get rid of it. And that's what we're going to do. But so, yeah, I'm all in favor of getting rid of that provision, because it doesn't make, we've solved that problem. That's not going to be, that shouldn't be part of this. So let's move on to the next piece.
John?
I guess I just say to the extent that you're going to get rid of that piece, it would be section 12 of the bill would just go away. That would remove any confusion, and that would leave it into the current law, which is if you are registered, which would only be the grandfathered ones, you get to go onto the lake. Otherwise, you wouldn't.
Okay. Thank you. Representative Wardway.
Yeah, well, I thought we're going to move on. And if we could move on to the next section that I have an issue with, and that was the antiques and the funding. If we're going to cause some funding issues, I don't know as I'm interested in that.
Mr. Chair?
Yes, Representative Martin.
Yeah, thank you, Mr. Chair. I have the same issue, and I'd like to see if we can possibly have somebody from the department explain the dollar amount and the fiscal impact, and if, in their opinion, there's any way to correct that.
All right. Who from the department can best answer that? I see 2 or 3 people on here. I see Bill Swan with his hand up. So go ahead, Bill.
Do you guys want a short version or a long version?
Yes.
I'll give you this. How about if I give you the short version and then you can ask for the longer version afterwards?
All right, that sounds good.
So the department would propose that currently the $33 one-time antique ATV registration is currently designated to the ATV Trail Fund, correct, at ACF. The department would propose that the entire $33 one-time fee goes to IFW's enforcement fund instead, okay? The folks at ACF are good with this. They can chime in, they're on. And we believe, the 2 of us together believe that that would solve the issue.
Is that going to make an impact, though, on the general fund in any way? Is there going to be a fiscal note is what I'm getting at?
Okay, that's a great question. It would impact IFW's general fund still, but it in a negative way, but it would positively impact IFW's enforcement fund.
Okay. Representative Martin.
Yeah, and if I may, thank you, Mr. Chair. If I may, that would be great. That way, no executive power could remove that from the enforcement fund. Bill, how much money are we talking about here?
Yeah, the amount of money is really dependent on the number of ATVs that are actually registered as antiques. Right now, there's currently, last year, well, the year that we're in right now, there were 3,000 ATVs roughly that would qualify. In other words, 3,000 ATVs that are older than 25 years old were registered in this current year. So if all of those were registered as antiques, that would be about a $60,000 impact to IF&W general fund, because we get roughly, okay, 20 bucks. I'm just making rough numbers to make it easy. We get about 20 bucks to our general fund from every regular ATV that's registered on an annual basis. So if all of those, if 3,000 times 20 bucks every year, it would be $60,000. So that's what you're talking about.
Thank you.
Representative Ordway.
Yeah, I don't think I'm interested in this antique thing. I tend to look at the antique automobile registration as one of the most neglected laws ever passed by the Maine legislature. I mean, to me, it's just doesn't work. It's not enforced, and I'm not interested in this because I think it's just going to grow. I mean, as time goes on and ATVs come, I think the losses are going to go beyond $60,000 as time goes by.
So are you saying, Representative Ordway, you'd like to see Section 9, 5C just taken out of there completely?
I personally would, yeah, and I don't remember this conversation from last year as part of the task force. Maybe somebody that was there could come up with some wording on that. I just don't recall it. I'm pretty sure I would have been opposed to it last year too.
Deputy Commissioner Peabody, would you like to weigh in here? Then we'll go over to
Yes, Mr.
Bronson.
Chair. This was a recommendation of the task force, and I'll give a little quick background. When the recommendation to go to $70 for a registration for an ATV was proposed, and that's primarily for trail maintenance, there's quite a group out there, and probably a portion of this 3,000 that Bill Swan spoke of said, I only use my machine ice fishing. I don't ever ride the trails. I may go onto my neighbor's property or whatever, and my machine's 25 years old. And so this was actually an important part of the task force recommendation when the proposal was to increase the registration fee to $70.
Okay, thank you. Mr. Bronson, would you like to weigh in here on this?
So I would just concur what Deputy Commissioner just said. This was a significant issue with several of your other legislators as well. And our discussion the other day internally between the departments basically identified the $60,000 that Bill Swan mentioned. And what we had come to an agreement on and made a recommendation for was that the entire antique registration would go to the department, which in the first year would generate about $99,000. So in fact, there would not be a shortfall. Moving forward, we weren't sure what that would look like, but the bill allows us to revisit this every 2 years. So that would create a mechanism to prevent, the department losing money. The ATV community feels very strongly too about this, that we don't want people running around illegally unregistered, but people that have got 25, 30-year-old machines that they use primarily to haul their gear out and maybe do a little ice fishing with, don't necessarily need to be paying this higher fee of those that are riding on the trails. So this was heavily debated within the task force as to how to address the split of registration costs. The end result was this, which everybody on it agreed on unanimously. So I think with the agreement that we have between the two departments of this money going all to the IFW enforcement fund, seems like a reasonable solution that prevents a loss of revenue for anybody.
Representative Ordway.
Yeah, although if we're going to leave this in, I would like a definition of antiques other than the age. I know when we did, well, not we, I wasn't there. Antique automobiles, now they have to remain stock. So if, you know, somebody was to take a 25-year-old machine and put a brand new 2021 engine in it and soup it up, and they're going to ride the trails wherever. They're not just using it on the ice. I mean, so there would have to be some definitions put on this antique for me to buy it. It really would. And it would have to be similar to the automobile, would be stock units. It has to be stock. It has to be a 2000 or whatever, all around.
Okay. Are there other questions, comments? Representative Terrio.
Thank you, Senator. Yeah, I certainly think we're going to have to amend it also for this funding to make sure that the funding mechanism is correct, so we don't lose our general fund money. So yeah, I want to make sure that we amend it for that, John.
So that's all in that same section. That's the $33 fee, as well as some type of a definition of an antique of over 25 years. I guess the only question I have is, and maybe Lester, you can, excuse me, Representative Ordway, you can respond to this, but if I've got an old machine and all of a sudden the engine blew on it, but I just love my machine, so I got, you know, a newer engine and popped into it just so I could keep it running, and I still only use it for the same type of things. I realize we're getting off into a fuzzy gray area, but where would that fit? I hear what you're saying about stock and et cetera.
If we went to the automobile law, antique automobile, if you change the engine, it wouldn't be a stock unit, and it would not be allowed to be registered as an antique.
Okay. Thank you. I didn't realize that, since I don't have an antique auto. Other questions, comments? All right, so we're back now to trying to figure out the amendment here. Any thoughts?
Mr. Chair?
Yes.
And there was also another section that John had pointed out regarding penalty or no penalty on something, John.
Yes. So that was, it's section 13 of the bill. And it requires the dealer to provide the information about the oversized ATV to purchaser. And the section that is in, obviously the requirement would still be there, but there's no specific penalty in that section. The section that it was in last year was 13-161, which has a civil penalty associated with that if there was a violation. And the civil penalty is $100 to $500. And if it's also the general repeat offender provision, which if you commit 3 or more civil violations under IFW law within the previous 5-year period and then did this, it would be a Class E crime. So those are the penalties under 13-161. Again, the same requirement would be in either place. It's only a matter of whether you want to include that penalty provision.
I have a question for Bill Swan here in a second too, but Commissioner Peabody, did you have something you wanted to weigh in here?
Regarding this conversation, Mr. Chair, I was thinking about the question, and if the department does not have any ability to put sanctions on a person who continuously, as a dealer, does not provide the information as cited in law, I'm just wondering if we have any ability to do anything with a dealer if we don't have the penalty in law. I wouldn't see it as being used a lot, but as far as the commissioner's ability to revoke a license for a violation or not issue a license, it may create a challenge there, and maybe John Clark can take a look at that further. But I saw that as maybe an issue.
So is that as simple, John, as just changing the section that this resides under?
If you want to apply the penalty, then you would just move it over, and this is where it was last year, and put it in 13161, and that would apply. The penalty that applies to that section would automatically apply. So you could do that.
Okay, we'll keep that in mind. A question for Bill. We've had a little discussion over grandfathering oversized vehicles, and when I decide I don't want it any longer or whatever, I'm kind of stuck with it. I can't sell it essentially because no one can register it. I guess there's two questions here. One, do you know how many of those oversized vehicles are registered now? Number one. And number two, how difficult would it be to track if I did want to sell it to someone and it could remain being used in the state of Maine? If there was a mechanism to do that.
Yeah. So sure. As far as the numbers, I think I will defer to Brian Bronson, because I think about a year or so ago there was an analysis on that, and then we'll come back to the other question.
All right.
So the numbers that we came up with, which was based on the 2019 registration that we got from the manufacturers, based on the serial numbers, showed there was 354 machines in the state of Maine.
Okay. So we're talking probably less than 400 in case there was some more that's been registered over the last couple of years or something.
Yeah, definitely less than 500.
Definitely less than 500. Okay. So back to you, Bill.
Right. So I think your question is, I think, first of all, how would we know that someone had an oversized ATV that had been registered and still owned it? I mean, we have those records, the history of those records in Moses by serial number. So if there were a question, a warden or whoever would pull the serial number off the machine or off the person's registration, and actually the warden could look at that themselves, but they could also call in here. And so I think your second question is there anything that would prevent somebody from selling it to another person and that person registers it? There would be nothing in our system that would prevent that. The current law that you're looking at would prevent that, but you could change that. You could change that, and so then, if somebody new had the machine and here it comes down the trail and a warden says, "Where the heck did you get that thing?" And you said, "Oh, I bought it and it's grandfathered," and same thing. They'd pull the serial number off the machine or off the registration, look it up in Moses. Sure enough, it was registered 10 years ago. On your way.
Okay. That's good to hear. I think that makes some people a little more comfortable with that issue. Representative Danny Martin.
Mr. Chair, we're getting there. I want to ask a question regarding antique vehicles. The department, I'm sure, has a definition of an antique machine. Dan?
Who can answer that?
Question to the department.
Yep, Colonel Scott, I think.
We have definitions currently of an antique snowmobile, because that law is already in place for that. And that's basically what that is, right in the write-up is based on. It's more than 25 years old.
That's the only definition for antique snowmobile?
I believe so. It's just, it's an age, 25 years. That language was pulled right out of the antique snowmobile language.
Okay.
I'll check while we're right here, but.
Yeah, because that would go back to Representative Ordway. I know he was a little concerned about ATVs, if that's the only definition.
I in regarding to Representative Ordway's concern about beefing up an engine, I suppose if that's a concern, we could put in the statute that if you have an antique and it's a Skidoo and it's got a 10 horsepower motor, limit it to with the motor shut, limit it to a 10 horsepower mower. It's that simple.
Limited to the original specs of the machine.
Exactly.
So, Senator Dill?
Yes, sir.
So yeah, the antique snowmobile definition speaks to 25 years old. The antique snowmobile registration also speaks to 25 years old that is substantially maintained in original or restored condition. So that's the only additional verbiage. I'm not sure if that's in this ATV language or not, but they do use the terminology substantially maintained, excuse me, in original or restored condition. So that might speak to his concerns of, can you put a 2021 engine in it?
Yeah.
Right, and I think that's what Representative Martin was getting at too, that you kind of at the original specs. Representative Ordway. Does that fit the bill?
It does. If that wording went over to that the colonel just referred to, went over to this bill, I'd be okay with that.
All right, sounds good. Thank you. Representative Mason.
Thank you, Mr. Chair. I know on some of the antique auto registrations, I believe there's a mileage. You can only go so far from your home. You can't use it as a daily driver. There's certain perimeters that you can do with that plate. And like Representative Ordway say, I don't think it's enforced very much. Is there anything like this with the ATV or snowmobile as far as antique registration where you can only go so far or use it so often or anything like that? That'd be for
Scott.
It speaks to and from expositions, parades, and intermittent, what's the terminology? Hang on one second. Occasional personal use.
Right. And that's in the ATV provision?
No, that's in the snowmobile statute.
Okay. I don't know if that could be incorporated into that. I mean, I don't know. A thought. Thank you.
Deputy Commissioner Peabody.
Yeah, again, thank you, Mr. Chair. The task force actually recommended that they just allow them out on wherever they happen to be and not under the stipulations mirroring the snowmobile law. That's the task force recommendation on that because of the enforceability of it. It's an enforcement challenge to determine what the person's doing. And again, they recommended it actually not follow the snowmobile guidelines.
Other than I think the stock aspect of it is something we probably want to put in. Yeah. All right. Anyone else? Representative Terrio.
Thank you. Yeah, so I kind of agree with that. I'd like to see that language put in to move that forward with stock. But the other piece that I want to make sure that is take that oral notification from the dealers and sellers and put it to what Inland Fisheries is going to make up the language and make it mandatory that they hand out a written information. I think that's a really good upgrade.
At the dealers, you mean?
Yeah.
Yeah. And then that would go on to section 13-161. Is that correct for a penalty in there? Is that correct, John? Yes.
Yes, that would go there. And I think the two places that IFW was suggesting both for the dealers and for the registration agents, both just doing the handout as opposed to orally. So that could be changed in both places, which would be section 6 and section 13.
Okay, sounds good. Representative Mason, do you have another question? Oh. Okay. Representative Landry. You're muted, Representative Landry.
I'm not used to that. It may be an unnecessary burden, but if you're going to give me a handout telling me that there are restrictions with the machine I'm buying, I'd like to see somebody sign off and acknowledge they've received it somewhere. Having grown up in the insurance business, I know how people tend to forget what they've been told. Is that too much of a restriction to anybody?
Again, I don't have an ATV, so when I go in, and register my ATV, or I buy my ATV.
When I buy it.
When you buy it, okay, so when you go in to buy it, then that, when you sign your paperwork, that's just part of the paperwork that you could sign. And I don't think that would be an added burden. You know, it's just like when you buy a car. I mean, I realize it doesn't really matter to a way because you sign 2,500 documents, it seems like, when you buy a car. They just keep putting them in front of you. But it'd be the same thing here, you know, that yes, I received, you know, the educational material or whatever. I guess you can do that at the dealership. Representative Ordway.
All right, here comes the monkey wrench. Well,
I think I'm muted now.
Let's say I live in Freiburg and I go over to Conway to the Polaris dealer and I buy an ATV that's too big and I bring it home, and then I'm going to get stuck with, they didn't tell me that in New Hampshire. So I don't know, it just entered my mind because stuff like that does, but.
Sure.
How do we handle it?
Sure. I'm not sure what the resolution is of that, other than it's the law. Mr. Bronson.
I would just like to say that we've had at least one dealer who's been actively doing this for the last year. So I don't think the dealers, you know, if IFW makes up the form, there has a place on it for the dealer to sign and the purchaser to sign. I think that would be very much part of their normal process, because this dealer has actually been forcing people to sign if they want to buy an oversized machine, because he was on the task force and it was at least the task force understanding that they would not be allowed to be used on the trails. And so therefore he's telling them, if you buy this, you're not going to be able to ride it on the trail system. This bill actually will allow them to ride it on the trail system, but we're hopeful that you will amend that so they can't be ridden on the trails unless they have landowner permission. Thank you.
Other questions? All right. Are we down to where we want to make amended motion? Here's where everybody kind of shies away. Brian, did you have something else you wanted to add?
Yeah, in the permission required, it says the existing bill as written says that the new language, it says including by limiting the size and weight of ATVs permitted on the landowner or lessee's property. And that's in addition to the sentence above, which says that the landowner or lessee, through agreements with the state or an ATV club, can, you know, manage the use. The problem has been the existing language has not been enforceable. So we have, for instance, landowners who don't allow motorcycles on their land, and we posted against motorcycles, but the wardens can't write them a ticket for riding without permission. They have to actually issue them a warning, and then the second time around, write them for trespass, and that requires the landowners to go to court, which they don't want to do. So I would like to suggest that where you have in the language where it says including by limiting the size and weight, you also add and type. That way the landowner could, you know, limit the size of a machine, and they could limit a type of machine, whether it's a motorcycle or a racing dune buggy or whatever it is, and that would automatically be enforceable under the permission required.
Okay. Colonel Scott, do you want to weigh in on that?
It would definitely help with the two-wheel motorized bikes. If there's some landowners on the landscape though who choose not to regulate any sized ATVs, and some that do, it's very possible you still would have to have the landowner come to court to speak to the fact that, yeah, it was my desire to not have those on there. I'm trying to think it through while I'm looking at it here, but if it's a specific landowner request that is different from the next landowner down, they would have to make some kind of an appearance for evidence. I don't know if that's exactly what you're getting at, Brian, or not, but that's unless it excluded that particular type altogether. But if it's a landowner choice, if it actually goes to court in order to present your best evidence, we're going to have the landowner there to say these are excluded.
Right. Well, the intent, the discussion within the task force was to try to put this into law so that if they didn't allow bigger machines, if they didn't allow motorcycles, we could post that accordingly and it would be enforceable without them having to go to court. Maybe that's not doable, I don't know. But I know that the motorcycle issue has been a hot topic with several large landowners. And we've signed against it, but we've never been able to successfully write tickets on people driving two-wheeled motorcycles where on the ATV trail if they're registered as an ATV, unless the landowner is willing to go to court, which what the landowners said in the task force was they wanted this streamlined so they didn't have to send staff to court in order to get enforcement of their wishes.
Sure. So I see what you're saying. So typically, if you do it today, it would be a criminal trespass situation because it was signed that the ATV couldn't go on there. If under the new law, if it's stated that certain size ATVs can't go and we can show that it was signed, very possible that the courts would allow that as best evidence, but no guarantees.
Right. Well, that's why I was just thinking this right here, the language says size and weight. Size and weight doesn't get to the type. So I thought maybe if you just added the terminology type or model or something like that, then that would allow the restrictions that are in place right now on motorcycle use to actually be enforced and not somehow left out of this whole process.
It wouldn't hurt, that's for sure.
Thank you both. Representative Terrio.
Then I say we put that in. I'm okay with that.
All right.
And I would make a motion ought to pass as amended.
Okay. What are all the amendments? It's been moved before we move on to a second.
That's all up to John.
John, what have you captured? What have you captured, John, for amendments?
Before I list them, I just want to make sure I understood that last change, which was because there was mention of motorcycle. If the language is changed to size, weight, and type of ATVs, is that going to cover motorcycles or is it type of vehicle?
No, they cover ATVs because we're talking about motorcycles that are registered as ATVs. The others are prohibited anyway.
Gotcha. Okay. So let me see if I can go down through the list then. The antique all-terrain vehicle definition would be amended to reflect the same language that comes from the snowmobile antique, which is it not only has to be 25 years or older, it has to be substantially maintained at original or restored condition.
But I just say that that's actually in this bill already.
That's right, it is there.
So you really don't need to amend it.
That part of it, you don't.
There's a definition and there's a spot that speaks to antique ATV, and the current bill is exactly like it is in the current snowmobile language. There's a definition in there.
So, okay, so it's not in the definition of the antique, it's in the definition or it's in the provision for who can actually register. And that you're comfortable with it being there as opposed to in the definition. Is that, if that's satisfactory, then we don't need to amend the definition of antique.
But under what section is the definition?
So the definition is under section 4 of the bill. An antique ATV is simply one that's 25 years old and is registered.
I would feel better if you had it in both places. Personally, that way there's no ambiguity to it. You know, one place it just says 25 years, and then the next place it says 25 years and substantially the same. I don't know if there's an argument to be made by anybody that says, hold it, you know, it says 25 years, even though it says something else later.
I mean, from a drafting point of view, it would make the most sense, unless there's some other reason,
to have all of that under the definition and then simply say, if you meet this definition, you can
That's
get
fine.
registered as an ATV. You don't need to repeat any of it then, you just,
Okay. That would be in section 5C then?
so 5C, you take out the language about what's 25 years old and blah, 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 and simply say an antique ATV. And then that way, the definition is it's 25 years old and it's got this, it's substantially the same. And then you can get that registered as an antique.
Okay.
It would need to be a little bit of adjustment of the language there, those two provisions, but I think that would capture it.
Representative Ordway, did you have a question on this section?
That would be my intent, as long as we don't have the wording of the limited use like there is in snowmobiles.
Right.
That is just an enforcement nightmare to me.
Yeah, sounds good. Okay, continue, John.
Okay, so, and then in section 9, where the antique ATV registration fee, $33, it would, the amendment would be to have the funds from that go not to the ATV Recreational Management Fund, but instead to the DIFW's ATV Enforcement Fund.
Okay.
The next change would be in section 8 of the bill, which is the definition or the provision relating to oversized ATV. The language in that section, which says registration for an oversized ATV may not be transferred, would be struck, so that would be possible for the same ATV to be registered by a subsequent owner. Section 12 of the bill, which talks about the operation of an oversized ATV on frozen bodies of water, that would simply be eliminated to remove that provision. Section 6 of the bill, and also section 13 of the bill, which talk about the registration agent and also the dealer providing explanations to about oversized ATVs to either the buyer or the registrar of the ATV, remove any oral explanation and make it clear that this is a written form that DIFW puts together, and DIFW would have it so that there would be some sort of signature line on that, so that the whoever is receiving the in the case of the buyer instance, the purchaser would sign off that they got this information. And I think the final change is moving the provision relating to the dealer providing the explanation from 13.160 to 13.161, which would simply mean that the penalty provision that applies would apply to that provision. I think that's.
Did you mention section 11 that you were adding type in there?
I'm sorry, yes, and that absolutely, yes. Section 11, adding type at the, so size, weight, and type that the landowner could. Yeah.
Representative Terrio, does that cover what you've wanted?
I believe that is absolutely going to be fine.
Okay. I will ask for a second, then we can have discussion. Representative Alley seconded it. Yep. Okay. Representative Ordway.
Another thought that came into my mind. Because I see them on the trails. Electric bicycles. Now, do they have to be registered, and do they look like a mountain bike? They pedal like a mountain bike, but they have electric assist. And I was just wondering about how those uses affect the trails. Anybody, I guess. I don't know. They don't have to be registered, as far as I know.
Mr. Bronson, do you have any thoughts on that?
They do not have to be registered at the moment. Those are defined in another part of the law. I think it's under motor vehicle, but they have motorized bicycles, and there's two different categories. And they fall under that designation. They do not fall under the ATV definition, to my knowledge.
Okay. Other discussion, questions, comments?
I still
Seeing
need a
none.
second. I need a second.
That was Representative Valley. He already did. That's why we're on discussion. Seeing none, Linda, would you call the roll, please?
Yes. Representative Mason,
Yes.
Representative Hepler,
Yes.
Senator Curry,
Yes.
Senator Black,
Yes.
Senator Dill,
Yes.
Representative Landry,
Yes.
Representative Terrio,
Yes.
Representative Danny Martin,
Yes.
Representative Ordway,
Yes.
Representative Ali,
Yes.
Representative Nadeau,
Yes.
Representative John Martin, I think has left. Then that would make it 11 in favor, 2 absent.
Okay, on LD 1434, an act to clarify all-terrain vehicle registration requirements and establish regular maintenance of designated state-approved all-terrain vehicle trails ought to pass as amended 1102. It passes as amended. Representative Martin.
That was LD 1439, correct?
Yes, yes. Did I say it wrong?
Yes.
Sorry about that. I was looking right at it too. I don't know what I read, but we're going to take a break for lunch here. But first, Representative Hepler.
Thank you, Mr. Chair. So did I miss a
Yes.
vote? I had to hop off for a work session.
I think you missed 2 votes actually, and I
Okay.
think Senator Black missed 1. So let's do those, and we'll go.
Okay, and they are
944,
and the committee vote. The committee vote was
ought not to pass.
unanimous.
I'm sorry?
Was it unanimous?
Yes, it was for those present.
Okay, I also will vote ought not to pass.
Okay. And then 1244 was missed both by Representative Hepler and Senator Black. And that was ought to pass. And that was also unanimous for those present.
Okay, I will also save that. Wow, I missed all the ATVs and snowmobiles.
Fine with that too.
And
Yeah.
Senator Black is yes also. Fantastic. That brings us up to date.
All right, with that, let's take a break for lunch. It's 12:55. How about if we come back at 1:30? I'll give us 35 minutes. Thank you, everyone. Well, everybody's quiet.
Oh, yeah, I was just, before we get started, Commissioner Camuso, if you would pass on my congratulations to Warden Kluge, an excellent choice. Just top-notch individual. You couldn't have picked a better guy. You really couldn't. I've had several interactions with him, and he's just a quality shows in your department with that guy.
Thank you, Representative. I will be sure to pass that along, and hopefully Colonel Scott can hear that as well. I'm sure he's probably in the waiting room, but I appreciate that feedback.
That's how they grow them in Dexter.
Yeah.
That's
And
right.
Representative Vaughn, we wanted to add, he was only arrested 3 of those many times that.
Apparently, I
Absolutely
hear my
not.
vote in the last vote, right?
He's just quality. Really,
Yeah.
you hear things, but just a pleasure to interact with in the woods. And we did a civil function together, and he was just unbelievable. Just really like the guy.
And if we can only convince Representative Wardway to stop buying his snowmobiles in New Hampshire, that would be.
I had to pay the sales tax, Danny. Come on, you pay a use tax, you pay a sales tax. I paid it.
And with that, we are back. So we're ready to begin. We have 3 more work sessions ahead of us. Hopefully they won't be too bad. And so I'll open up the next work session on LD 1081, an act regarding the special guides permit drawings. That's Representative Andrews' bill. And with that, John.
Yeah, so this bill would change the separate moose lottery that's now available for hunting outfitters for the sporting camps to a lottery available to any licensed hunting guide. Currently, an outfitter who obtains a permit can sell the permit as part of a package deal involving food, lodging, and services of a guide. Under the bill, this would be eliminated. The guide who obtained the permit and sold it to the person would simply need to accompany that person on the hunt. That's pretty much all I had. I just want to remind you again that you had LD 544, which the committee voted on not to pass, which was related, having to do with eliminating that special lottery for the outfitters, sporting camps, and LD 433, which the committee had voted on not to pass, which was to allow moose sub permits to be sold. So that's what I have on that.
Great, thank you. Representative Danny Martin.
Thank you, Mr. Chair. To expedite this process here, since this is very similar to, as John pointed out, a bill that we defeated unanimously, I would move ought not to pass.
I'll second that.
Been moved and seconded by Representative Theriault. Any further discussion? Seeing none, Linda, please call the roll.
Yes, Representative Mason,
Yes.
Representative Hepler,
Yes.
Senator Curry is not present. Senator Black,
Yes.
Senator Dill,
Yes.
Representative Landry,
Yes.
Representative Theriault,
Yes.
Representative Danny Martin,
Yes.
Representative Ordway,
Yes.
Representative Alley,
Yes.
Representative Nadeau,
Yes.
and I don't believe Representative Martin has come back.
Yeah, Representative John Martin's there.
Oh, he
Yes.
is. I'm sorry. I missed you. And your vote, sir?
Yes.
So that gives us 11 in favor of those present, 2 absent.
Okay, on LD 1081, an act regarding the special guides permit drawings ought not to pass, 11-02. And we will close the hearing, the work session on 1081. And we'll move on to LD 1153, an act to restrict combustion engines on Weber Pond in Bremen. And this is Representative Kraft's bill.
So this bill would prohibit the use of any watercraft equipped with an internal combustion engine on Weber Pond, except it would allow watercraft with an engine to be operated by a person who resided on the land abutting the pond as of January 1st, 2021.
as long as the person continues to reside on that land, the watercraft is equipped with a 4-stroke internal combustion engine of no more than 6 horsepower, as long as the watercraft has a valid registration in that person's name on the effective date of the law. A couple of sort of background notes here. I think it was mentioned at the public hearing, there's already a 10 horsepower limit on Weber Pond that is under DIFW's rules. And as you recall, DIFW does have the ability to adopt by rule horsepower limits on ponds. That's a process which they do, again, through the rulemaking. And it's based on a petition from municipal officers or in the unorganized territory from county commissioners, or from on a petition from 25 citizens. And the standards there are, they look at the area of the water, the use of the waters, the depth, the amount of traffic, and ensuring public safety of persons and property. So again, there's already a 10 horsepower limit on Weber Pond. I think the IFW has suggested they were not aware of a public launch on Weber Pond. And the other thing that's worth noting is the regulation of watercraft is at the state level. Local regulation is preempted by state law. So these are state issues, and towns are not allowed to adopt regulations with regard to watercraft. The only other thing that I guess I should mention, DIFW had mentioned concerns about the complexity of enforcing the provision, the exception for persons who resided on the lake. And given the way that this is structured, I should at least mention, I'm not saying I can give you a definitive answer, but it potentially raises equal protection issues to have a provision which says that someone who lived on the property by the lake at a certain date has a different ability to use the pond than other people. So that raises an equal protection issue. Again, there may be a basis for that distinction, but there is at least a question that gets raised by that distinction.
Representative Danny Martin.
Thank you, Mr. Chair. And that's exactly my issue. Since there is no public launch site that I, as a member of the public, could use, and because there is no such public boat launch site, that means that the Department of IFW does not stock it. So unless I'm an owner on that pond and I have a cottage, there is no way that I could ever fish there or canoe there. And because of that issue, I will be opposing this piece of legislation.
Thank you. Any further questions for John or comments? Anyone else that anyone wants to hear from the department? No one? Representative Ordway.
I would make a motion of ought not to pass.
It's been moved, ought not to pass. Is there a second? Seconded by Representative Alley. Any further discussion? Seeing none. Linda, please call the roll.
Yes, starting with Representative John Martin,
Yes.
Representative Nadeau,
Yes.
Representative Alley,
Yes.
Representative Ordway,
Yes.
Representative Danny Martin,
Yes.
Representative Terrio,
Yes.
Representative Landry,
Yes.
Senator Dill,
Yes.
Senator Black,
Yes.
Senator Curry, no, Representative Hepler,
Yes.
Representative Mason.
Yes.
And so that again makes it 11 in favor, 2 absent.
Okay, on LD 1153, an act to restrict combustion engines on Weber Pond in Bremen. Ought not to pass 1102. I will end the work session on 1153, and we'll open up the work session on 349, an act to prohibit the use of personal watercraft on Kai's Pond in the town of Sweden. And this is Representative Millet's bill of I believe that's on the table. Is that correct, John? This was tabled?
Yes, it was tabled. You had heard it, and then you'd worked it and you tabled it to allow the department to come back to talk to you about how to deal with these types of bills, this one and others that might be coming along in the future.
Okay, can I have a motion to take this off the table, please?
So moved.
Representative Landry, is there a second? Representative Mason, it's been moved and seconded. All in favor, just raise your hands, please. It is off the table. Continue, John, please.
So just to remind you, this is the bill that would add Kai's Pond to the town of Sweden to the list of water bodies in statute that prohibit the operation of personal watercraft. And again, just to remind you, regulation of watercraft is a state issue. It's preempted at the local level. And unlike with horsepower limitations, actually prohibiting personal watercraft is a statutory provision at this point. There is no rule-making authority by the department to prohibit watercraft. And as you recall, the previous process for doing this was the Great Ponds Task Force back in the late 90s, which resulted in the list that's in statute now. That process is essentially over, but and that's why the bill is here. Is the only way to add these is either to come to the legislature and ask to have a statute added. But I believe, again, the department has been looking at this and thinking about both this bill and generally the process for trying to deal with these kinds of requests.
Great. Thank you. Other questions for John? Okay. Commissioner, anyone want to speak on behalf of the department?
Sure, Senator. Thank you. I will. Again, I'm Judy Camuso, Commissioner, Maine Fish and Wildlife. Senator Dill, Representative Landry, and members of the committee, thank you for this opportunity to provide some background information on LD 349, but I think it pertains to several other bills as well. As you all know, Maine lakes, ponds, rivers, and streams are public resources held in trust by the state. Stewardship of freshwater fish and wildlife, along with the oversight of public use in these waters, is the responsibility of the Department of Inland Fisheries and Wildlife, as well as other natural resource agencies. Part of this responsibility and oversight comes with supporting safe operation of watercraft on inland waters. Public waters are traditionally, culturally, and economically important in supporting water-dependent recreational uses, including boating, that contributes to Maine's unparalleled quality of life and vacation destination. The department remains committed to providing equitable public access to these public resources, as well as supporting broad public use opportunities. The waters offer recreational opportunities for the greater public benefit, for the greater general public, most of whom who do not have the means to live adjacent to these public recreation areas. Living adjacent to public recreation area requires an acceptance to share and tolerate activities by the general public and neighbors in close proximity to waterfront homes. User conflicts between the public and waterfront property owners have been addressed through promulgation of numerous laws that equitably applied statewide to promote responsible boating behavior, irrespective of the watercraft and motors being operated. The department supports an approach to managing public waters of the state through the establishment of appropriate laws that can be applied consistently to all waters statewide. This approach balances statewide concerns related to safety of persons and our property and our natural resources. Adoption of boating laws specific to individual waters not only will complicate boating laws, but will be a barrier to public participation on public resources, as well as unnecessarily require the public to make expensive investments in different motors and watercraft without really addressing the concern in most instances, which is responsible boating behavior. The Coast Guard and National Association of State Boating Law Administrators strive to establish national safety standards that are consistently applied to all waters, creating a common awareness of boating safety for all boaters everywhere in the country. The department supports the advancement of standardized boating laws that apply equitably statewide. The current suite of state laws and rules that govern boating operations in Maine provide broad oversight and address many undesirable boating behaviors. As a result of the public hearing on LD 349, the department was asked to provide background information on how municipalities were instructed to review a proposed ban on personal watercraft use on certain water bodies during the Great Ponds Task Force that occurred in the late 90s into the early 2000s. We were additionally asked to provide our thoughts on the path forward for future requests on water body surface use restrictions. With an increase in outdoor participation, particularly due to the pandemic, we have seen several bills this session focus on safe, respectful boating or limiting use on water bodies. Those include LD 349 as well as LD 184, an act to minimize propagation of invasive aquatic plants, LDs 89 and 114, airboat operation restrictions, LD 349, an act to protect Maine's loons and other water life in the issuance of permits to hold a regatta, race, or boat water ski exhibition. LD 646, an act to clarify temporary mooring privileges for mooring on inland waters, and LD 1153, an act to restrict combustion engines on Weber Pond in Bremen. The original Great Ponds Task Force was formed by the 115th legislature in 1992 and began its work in 1994, focused on the same issues we face today, environmental concerns and surface use conflicts. A number of the current recreational boating laws we have today, specifically around surface use, were enacted as a result of the task force work and ultimately their final recommendation to the legislature. A couple examples include imprudent operation, such as prolonged circling and wake jumping, watercraft noise limitation, age requirements for operating a personal watercraft. The 118th legislature in PL chapter, Public Law chapter 739 provided a 2-year process for municipalities to propose personal watercraft bans on certain water bodies. I will summarize the unallocated language in section 17 of that law. A municipality, with the approval of its legislative body, may submit recommendations to the Commissioner of Fish and Wildlife for regulating use, operation, and type of watercraft on a great ponds within the jurisdiction of that municipality. For great ponds that border more than one municipality, recommendations may be submitted only after approval by the legislative bodies of all municipalities in which those waters are located. For great ponds that border lands within the jurisdiction of the Maine Use Land Regulation Commission, the approval of the commission is also required. If a municipality chooses to prepare recommendations for such waters, it shall take into consideration the use to which those waters are put, the depth of the water, the amount of waterborne traffic on the waters, wildlife and environmental values, noise, traditional uses of the water body, and the safety of persons and property. These recommendations may be submitted only after a public hearing and must include a description of the resources the municipality or municipalities will use to enforce those regulations if enacted. The commissioner submitted a report back to the legislature on the proposals received. The reports were accompanied by legislation implementing the municipal recommendations supported by the Department of Fish and Wildlife. The considerations outlined in that process, the depth of water, amount of waterborne traffic, etc., did not have measurable standards for the commissioner to consider. Accordingly, the department submitted all proposals that had appropriate municipal hearings and provided some means for enforcing PWC prohibition. These proposals were accepted by the legislature, and the personal watercraft bans, and are currently, those are the current bans that came from the Great Ponds Task Force. The department is not in favor of reenacting this process without measurable standards, as it would be very challenging for the municipalities and the public. The department would like to take a broader education approach with the increase in outdoor recreation and new people engaged in the use of our public resources, as we feel it is the people need to be better informed on all aspects of responsible use of our public waters. Enhanced voter education was also a Great Ponds Task Force recommendation that was never fully implemented. The department feels we are in a very different place 25 years later to deliver voter education, and we look forward to working with the committee on that approach. I'd be happy to answer any questions.
Thank you for the briefing, the update. Questions, Representative Danny Martin.
Yeah, thank you. Question to the commissioner. Have you been petitioned or have you had submitted to you a recommendation from a particular municipality regarding this body of water?
Thank you, Representative Martin. So we've had, in addition to the bills before the legislative committee, we've had several proposals submitted with petitions for limiting horsepower on smaller bodies of water. Does that answer your question?
Regarding this particular issue?
Oh, no.
That was the question. So,
okay, sorry.
So the municipality has not fulfilled its obligation to submit a recommendation to you?
Not that I'm aware of. I mean, I'm not sure, Representative Martin, that is still the required process. This is what happened back, as a result of the Great Ponds Task Force. It seems like it was a one time, like they reviewed them all, and we got all the recommendations. As long as the municipalities adhered to the process, we just approved them. There was no real debate, or there was no opportunity for us to deny or not recommend moving forward. So basically the municipalities held the hearings, they passed it to us, we passed it to you, and they were all enacted. That's a simplified version of my understanding.
Great. So what was the department's position during the public hearing regarding this bill?
I think we basically just provided, we didn't particularly take a position, we just provided the opportunities for what sort of complaints we've dealt with on the water body, not necessarily in support of it.
Right. I wonder, Mr. Chair, if we could hear from the sponsor.
Yep. I was just going to call him next. Representative Millet.
Thank you, Mr. Chair, and thank you, members. At the hearing on February 22nd and the work session on March 22nd, we acknowledged, both me as a sponsor and 3 local supporters, that we were unaware of the municipal vote requirement. Some of us, myself included, remembered some of the aftermath of the report that Commissioner Camuso mentioned in the 118th, and felt that there had been some occasions where further designations had occurred without that municipal factor. However, immediately after the hearing, the proponents approached the selectmen in the town of Sweden and asked to have the question put on their town meeting. That was at the time, February 22nd, or the day following. It was too late to get anything on the town meeting in March. So at the work session on the 22nd of March, I and Andrew Black, who testified at the hearing, and others suggested that we would go out of our way to make sure that the municipality was given an opportunity to weigh in on the proposal, and offered 2 ideas. One, to simply carry the bill forward to the second regular, with the understanding that the town meeting in March of 2022, or if there were to be a special meeting between now and then, would clearly place the question before them. The second alternative was to, if you were disposed to consider the uniqueness of Kai's Pond, which is, to my knowledge, never had recreational vehicles using it for over 100 years, we're willing to provide a delayed effective date subject to a majority approval to make this designation official. That would also be an acceptable alternative to the constituents in Sweden. It was at that point that I think Representative John Martin proposed the tabling motion to get the feedback from the department that you just heard. So I just want to make sure that you all understand that it was my error. I'll take the responsibility for not knowing the aftermath of the 118th session. But clearly, there is a fair amount of support for this. And we would like to work with you to at least keep the bill alive and allow the town to do its proper due diligence.
Are there other questions anyone has? Any questions for Representative Millet? Representative Terrio?
Thank you, Senator. Is Sweden the only town that this body of water is involved with?
That is my understanding, Representative.
Any other questions? Representative Danny Martin?
Mr. Chair, would the chair entertain a motion to carry over?
Let me ask a question of John Clark. John, how many bills do we have now? Are we carrying over?
So right now you have 3 that you're carrying over, or that you requested to carry over. And my understanding is from the directive from the presiding officers that you will probably be limited to 5. So this would boost you to 4 and you'd have 1 left.
Or we could turn it into a resolve and do something in between and have us report out next half of the session, and it's not a carryover at that point. Is that correct, John?
Yes, you could direct the department to continue to think about this issue and report back next year.
Just curious. All right.
Yeah, I'm sorry. Either way would be great to allow the sponsor the opportunity to have the municipalities chime in on this matter.
I agree, and I think if we do the resolve that way, we don't tie our hands if we're truly limited. And I don't know what we've got coming up that we may want to carry over. We still have a couple of, interesting bills, I guess I would say, that we may want to carry over. So I think resolve would be a good way to go. Representative Terrio.
Then I'll make a motion that we make this a resolve and have the department continue working on it.
Second.
And we'll report back next year and report on the bill if needed, right?
Yeah.
Okay. It's been seconded by Representative Landry. Any further discussion?
Can I ask a question, Mr. Chair?
Sure.
With the language of that returning the bill to the department's purview, allow for the question to be posed at the March town meeting in 2022 with an update to this committee that would consider the requested authorization that's in the bill?
I guess my first question to you is, Representative, when is the date of that meeting? Do you know?
Not set yet, but they usually meet on the 2nd or 3rd Saturday in March. So certainly be before adjournment.
Okay. Yeah, I assume as long as we have it before adjournment, we're okay. So I don't see any problem with that. I assume that's what you meant by your resolve, Representative Terrio, is to include whatever the town can do. Right.
Absolutely. That's the whole point of the resolve, is to make sure that we hear from the town.
Yep. Is that okay, Representative Millet?
I'm happy to work with you on it. And yes, it opens the door and that's what I'm looking for.
Great. Any further discussion? Seeing none. Linda, would you call the roll, please?
Yes. Representative Mason.
Yes.
Representative Hepler.
Yes.
Senator Black.
Yes.
Senator Dill.
Yes.
Representative Landry.
Yes.
Representative Terrio.
Yes.
Representative Danny Martin.
Yes.
Representative Ordway.
Yes.
Representative Alley. Representative
Yes.
Alley. Representative Nadeau.
Yes.
And Representative John Martin.
Yes.
So that again is 11 in favor, 2 absent.
Okay, on LD 349, an act to prohibit the use of personal watercraft on Kai's Pond in the town of Sweden. It passed as resolved 1102. And I will close the work session on LD 349. I believe Representative John Martin, you may have missed a vote on LD 1439. An act to clarify all-terrain vehicle registration requirements and establish regular maintenance of designated state-approved all-terrain vehicle trails. It was an ought to pass as amended 1102.
I vote yes.
Okay.
Very good. Thank you.
John, Arlinda, anything else? We
The
have,
only thing that I don't really have anything that you got an email from Rachel, just remind you having to do with the fiscal note on LD 20 or 280 as the snowmobile registration fees. And as you can see from the fiscal note, it raises, I guess, a little over $1 million in new revenues for snowmobile purposes. So
okay.
I'm assuming there's no issues with that, but just wanted to make sure you got that from her and you're all set.
Great, thank you. Anything else?
And that's all I have.
Linda, anything from you?
No.
Could I have a motion to adjourn? Representative Terrio, seconded by Representative Mason. All in favor, give me a wave. Thank you.